For judgment item number 1, OJC 3721 of 2002 and batch of matters.
You've disposed of the petitions with some observations.
Item number 2, CRLA 29 of 2003.
The appeal is dismissed. The appellant will surrender by 26th August.
For judgment item number 3, JCRLA 14 of 2011.
The appeal is dismissed. The appellant should surrender by 26th August.
Item number 4, WPC 7584 of 2014.
We've ordered compensation of 10 lakhs to be paid to the petitioner.
Mention. List fresh admission item number 5.
Item number 5 may please, my lords. This is a public interest litigation, my lord. But here the issue involved is twofold, my lord. But firstly, my lord, when this writ petition was filed, my lord, at that point of time in Odisha, number of places the family judge post was lying vacant. But that is the first part of submission. But to that submission, Lordship may ignore because in the meantime, it has been appointed. But the second part of submission, my lord, that is a vital part, my lord. that is also twofold. Lordship may kindly appreciate, my lord. As per the Family Courts Act, my lord, Section 4 specifically provides that 3 categories of persons can be appointed as judges of the family court. My lord, firstly, lordships know, firstly, my lord, a judicial officer having 7 years of experience. Secondly, my lord, a practicing lawyer with 7 years of experience. And thirdly, my lord, any person as may be provided by the central government with concurrence of the Chief Justice of India. But so far as this appointment is concerned, my lord, as a matter of practice, it has been going on that the judicial officers have been appointed. But there is no issue to that effect. But so far as the appointment of lawyers are concerned, my lord, there is no procedure as to how they are going to be applied, going to be appointed. My lords. But that is the sole issue, my lord. I have placed on record the rules also.
Why in the air? What is the context?
But the context is not when a statute provides a particular.
No. Is there any recent appointments made or something which you say lawyers should have been appointed and not judges?
I'll satisfy. But there is a case, my lord. But suppose lordship knows, but in the event there is an advertisement, then the lawyers will get the opportunity either to apply or any other person who is eligible, they may apply. So it is not the case here, and the statute and the rules does not provide for so. But when the judicial officers are appointed, my lord, the lawyers are not getting the opportunity to even participate, my lord, to even apply.
Let's see your prayer. Come
Yes,
to the prayer.
Lord, yes, my lord. My prayer is twofold.
I don't see any two. Only one prayer is there.
Lord, 2 is there. Lordship. Page 15, my lord.
Yes. Frame rules, guidelines for selection of eligible candidates, you say.
Yes, my lord.
But that's neither here nor there. You're not saying why are lawyers not getting appointed.
Lord, it is, in fact, my lord, that is my case, my lord. My
Prayer
sole
is not
case
like
is
that, sir. Your prayer is general, as if there are no rules at all for appointment of judges in family courts.
Lord, there is a rule, but so far as, but lordship may kindly appreciate, my lord, the situation may arise, my lord. A judge is eligible.
Let's
But I have annexed. I have annexed. Annexure 1.
All right.
Annexure 1, my lord. At page 17.
Yes.
This is section 4, my lord. Section 4, subsection 3.
Yes.
But when a situation arises, my lord.
No. There must corresponding rules must be there.
Yes, my lord. That is I also have annexed. That is there, my lord, on record. Annexure 2 series. But the rule provides, but that does not provide how a lawyer is going to be appointed or how a judge is going to be appointed. It only provides the eligibility criteria. But how this is going to be implemented, but that has not been provided in both the rules. 2 rules are operating. One, my lord, it has been framed by this honorable court, my lord, and the other one by the state. But both rules I have placed on record. It does not provide for the procedure, how it is going to be appointed. And that is the reason why, my lord.
No, this has to be done by each state, is it?
No, by the state, and it also
No, but in any state in India have they framed rules for lawyers?
Yes, my lord, bow down. In fact, my lord, the Family Courts Act also empowers this honorable court, my lord, to frame rules. Section 21.
Have you got an instance of in any other state in India?
Yes, ma'am.
Where they have framed rules for appointment of lawyers as judges of the family courts?
I will have to examine that.
You will do some homework. See, the thing is, we can't, and also this is suddenly in a vacuum. I don't know.
My humble submission would be, my lord, when Section 4 provides for appointment of lawyers, my lord,
no,
then
we're just having an academic discussion. I don't.
Yes.
Are you wanting to get appointed as a judge of a family court? No, I'm just saying.
Yes.
This is a PIL, right?
Yes, ma'am.
So who are the people really wanting this? I'm not at all clear. Has some bar association passed a resolution? Has the bar council come forward? Suddenly, you seem to have just sat in a place and thought about it, and you're filing a PIL. See, we can have lots of academic issues discussed.
True, Miller.
Why is this not there? Why is not there? It must lead to something, right?
True, Miller. My humble submission would be, Lord, when the Act provides a specific...
There are so many things we required to do which we don't do. All right.
Lord, there has to be a rule to that effect, Miller.
See, The thing
But
is,
that is my humble.
we have a lot of spare time.
Right.
Let's say like the American Supreme Court, we take up only 100 cases a year.
Well,
Then we can take up a lot of interesting academic issues, hear this at length for a whole day, 2 days, 3 days. We can do that.
Lord, if that
The
is
thing
not
is that
done,
we have enough to go by already.
Lord, my humble
There's so
submission
many
would be-
pressing issues.
Lord, my humble submission would be, if that is not done, my Lord, then the next two provisions, my Lord, that is appointment of lawyers and other person, that will be redundant, my Lord. That part of the
Sir,
act will be rendered
There are
as
all
redundant.
very neat questions, sir.
Yes, my Lord.
Remarkable how many questions can arise from this
Yes.
one provision.
Yes, ma'am.
Where is it leading to is the question.
Well.
As some lawyer said, my whole future is spoilt because this family court act, they have not framed a rule permitting me to apply. I don't see anything like that.
But if that would be so,
I don't
Lord,
see it.
Yes.
Or you should say, listen,
Yes.
lawyers in family courts in other states are doing brilliantly. Why is Orissa being deprived of brilliant lawyers coming and family court judges? Is that your case?
No, my Lord, it is a question of compliance of the provisions of the statute, my Lord. That is,
Sir, there are so many provisions of so many statutes in India which are not complied with.
Lord, that
If you
cannot.
start make a list, no. I'm
Lord,
saying we can bring up all such issues. And that's why I want the context. We have very interesting questions, no doubt, but there must be a context for it.
Lord, if a person will be,
See, you should be able to show in this state X, lawyers have been appointed in family courts. They have this wonderful set of rules. Look how well the family courts are functioning in that state. And Orissa, listen, there are no lawyers being appointed in Orissa. Therefore, we are suffering in Orissa because the family courts in Orissa are not doing very well. Lawyers are doing so well in other states.
yes,
Is that your case?
in that event, my Lord, there are few judgments, my Lord, which I have come across and I'll place it on record. Not today, I have not got, but they are providing for advertisement for appointment of judges of the family court, and that provides opportunity for others to apply. Lord, that
No, where's the others? If it's only judges, I'm just saying,
judges and other persons eligible as
No.
the statute provides. my Lord.
are there other states in India where
Yes.
family courts are appointing, the lawyers are being appointed to family courts? Have you done that homework? See, I think
I will
the way that you frame this petition is at a time there were no family court appointments being made.
True, my Lord. True.
You draft a proper petition focusing on lawyers, but give us examples of lawyers having been appointed to family courts in other states in India, or rules in other states which say that
Lawyers.
when
yes,
lawyers
Yes.
apply, this is the procedure we'll follow.
True.
Ah.
But I'll examine that, my Lord. Lord, you may grant me some time, my Lord. I'll examine this.
No, I think you need to
specifically.
frame a better petition, sir. You'll have to see the petition has to be a proper petition. It's not that as we go along, we'll pick up this, we'll pick up that. This is not a 5-year plan. You say, counsel, the petitioner states that you will withdraw this present petition with liberty to file a better petition, focusing on the precise issues that he wants the court to consider. Disposed of his withdrawn with liberty is paid.
We are appearing for opinion number 1 and 2. Let's know.
All right.
Supplementary list item number 6.
May I please? My Lord, the petitioner seeks to challenge the order passed by the London Lokayak, my Lord, directing for an investigation and including the
I thought
name
we
of
already issued notice in this. Has reply been filed? I thought notice was already issued in this. No.
no, my Lord.
Acha, you wanted to remove defects.
My
All right. Yes. What has the Lokayak done?
Your Lordship may kindly have a glance, my Lord. Under section 20 of the Odisha Lokayak Act, my Lord, subsection 1 of the section 20, my Lord, a provision is there for to conduct a direction for a preliminary inquiry. That was done, my Lord. In the preliminary inquiry, my Lord, I was not implicated,
No.
my Lord.
This impugned order is 27th May.
My Lord.
The direction is to complete an investigation against you in 3 months.
My Lord.
That must already be over now.
No, my Lord, it has not been.
Just 10 more days only. It'll all be over in 10 days. By the time we issue notice, they reply that 3 months' time is over. The report will also come.
My Lord, my instruction is that they have not they have only collected some documents. They have not
Whatever,
yet
there's a
started.
3 month time given.
Time was given, my Lord. But my humble submission is that, my Lord, under
So
section
we'll keep this after 27th. By then, if nothing comes, then we'll entertain.
Lordship,
If by then the report has already come, there's no point in entertaining.
Unless you may kindly protect me, other let them proceed, my
There's
lord.
no protection, sir. You have been so easy. When did you file this petition?
I petition in June, my lord.
Came up only in
Because
July.
the certified copy was not there, my lord. That's what problem, my lord. I could not obtain certified copy in time. That the defect was there, so I could not get it listed.
No, what is the ground? Why you're saying that they
Ground,
don't have
my
the
lord.
power to order investigation?
The competent authority, while the issuing such a direction, the London Locaयुct is supposed to be satisfied. A opinion, my lord, I'm placing my lord your lordship's permission, provided further that before ordering an investigation under this clause, the Locaयुct shall call for the explanation of the public servant and views of the competent authority. My lord, here the Honorable Minister of the Revenue is the competent authority. And he has opined that there is nothing against me. No allegation, my allegation against me is baseless, my lord. Your lordship may kindly have a glance. Page
No, are they bound by that is the question. They're only supposed to take the views.
No,
The view may be yes or no, but are they bound by that?
that
Is the Locaयुct bound by what the competent authority says?
already two inquiries, by both the inquiry wing of the Locaयुct, my lord, they conducted inquiry. They found that I have nothing, no involvement in it. Thereafter, a ADM level inquiry was held by the government. They also given me clean sheet. On basis of that inquiry report, the competent authority has opined that I have no involvement in this matter.
All right.
Still then, my lord, there has been directed my name to cause an inquiry, including my name, so that I shall be subject to harassment, my lord, for no reason. My lord. That is my whole.
Where is the provision?
20, my lord, subsection section 20 of the Odisha Locaयुct Act 2014.
Section 20 of
Odisha Locaयुct Act 2014, man.
Something else. Yes. Tell us section 20.
My lord. 20, the subsection, clause B of subsection 1, my lord.
Yes.
It provides for investigation, my lord.
Yes.
The two requirements there.
Yes.
First, there is the London Locaयुct is supposed to be satisfied with regard to prima facie case, which they have not got in their preliminary inquiry. And subsequently, other proviso is that they are supposed the views of the competent authority is required to be taken into consideration.
Correct. That has been taken. In fact, the impugned order says that.
My lord, the impugned order, your lordship, kind of what the observation is made so far my name is concerned, my lord. Your lord, have a glance at place 39, my lord, last part. I have no objection if that the cause and investigation one, but including my name, my lord, under the above circumstances, the fact, the situation, the possibility of involvement of the other officers of Miss Soren, my name is specifically mentioned, and Sikan Naji. In addition to Abhimanyu Bhuya, entire reports, my lord, all the investigation and inquiry reports makes it clear that Abhimanyu Bhuya, he who had received the money and issued the money received, he is responsible.
No, that nobody can act individually without support from others. That's the whole point, sir.
But that has been found in inquiry report, my lord. Both the reports, ADM level report.
No, but they're not binding, sir. The whole thing is that report binding on the Locaयुct is the question.
And that is the requirement under.
No. Does it say the language doesn't seem to indicate it's binding? Let's come back to section 20. Where does it say the views of the competent authority will be binding?
Binding my lord, it says that provided for before ordering an investigation
Correct.
under this clause, locaयुक्त shall call for the explanation of the public servant and views of the competent authority. So that has not been taken into consideration.
No, taken into consideration, sir. Come to the impugned order.
My lord.
Read para 2.
They have taken, your lordship may kind have a place 38. The competent authority views at the last part of 38. The competent authority, the Honorable Minister of Revenue Disaster Management Odisha Bhubaneswar, in its views has mentioned that matter was inquired into by ADM Keonjhar, who was held. Sri Abhimanyu Bhuya, ex-chairman cum assistant Nazir, responsible for misappropriation tax for 6,000. The competent authority has further stated that Sri Abhimanyu Bhuya is responsible for massive irregularities, embezzlement of government money collected as fine. Both the Srikant Jana and Sri Abhimanyu Bhuya have already been transferred from Tahsil Jhalli. The competent authority has also stated that allegation regarding misuse of power and position by ex-Tahsildar Mr. Gayateshwaran and nexus with sand mafias and illegal lifting of minor minerals are baseless and false, as found from the report of the ADM Keonjhar. So after this finding, my lord, this opinion of the competent authority.
No, only if it is binding. You see, one is to take views and consider those views.
Binding, my lord, that is the requirement, my lord, my submission, my lord, this required, provided that he is required to take all these things into consideration while directing for an investigation. I have no objection. I'll let the investigation be made, but so far as my involvement, involving my name by implicating my mail, I shall be subject to unnecessary harassment.
No, because they were explaining also. It's not a one-line order, sir. It's a very detailed order.
Detailed of that I said. Everything has been detailed. This finding has also been recorded by the looker. But still then, an observation has been made that will be.
What is the observation made?
That page, next page 39, under the above circumstances, last paragraph. Under the above circumstances, the fact situation.
So it says possibility of involvement. That's all. Cannot be ruled out. There's no finding here, sir.
By this observation, my lord.
And requires investigation. So obviously
without any observation.
These are not final views of the Lokaयुक्त Act also. You see, the only apprehension expressed by the petitioner at this stage in the present petition questioning an order dated 27 May 2022 of the Lokayukta is that there are certain observations in the said order which may prejudice the petitioner. As they may amount to prejudging the issue. So in particular, attention of the court is drawn to the fact that to the following sentence, which reads as under the bottom of page 39, under the above circumstances, top of page 40 cannot be ruled out till there. Learned counsel, the petitioner draws attention to the view of the competent authority, which has been extracted in impugned order, which states that the allegations against the present petitioner, open quotation, are baseless and false as found from the report of the ADM Keonjhar, end quote. Having considered the impugned order in light of the submissions of learned counsel for the petitioner, the court is of the view that the observations in the impugned order can at best be viewed as tentative and prima facie, and not conclusive in nature. Full stop. In fact, they only explain the circumstances under which the Lokaयुkt ordered the investigation in the first place. Full stop. Consequently, the court is not persuaded at this stage to interfere. The petition is accordingly dismissed.
Supplementary list item note 7.
Your Lordship, the petitioner herein seeks to challenge the resolution number 2824 dated 2nd of April 2022 under Annexure 2, Your Lordship, page number 20, Your Lordship, wherein it was published in extraordinary issue of Odisha Gazette dated 6th of April 2022 by Cooperation Department, Your Lordship. Your Lordship may kindly see clause G, page 20, Your Lordship, clause G, which has been categorically stated that the Odisha Agricultural Produce Market Act and its rules has been repealed by the Odisha Agriculture, Produce and Livestock Marketing, Promotion and Facilitation Ordinance 2020, although the ordinance have already been lapsed, Your Lordship, due to the efflux of time. To further substantiate, Your Lordship, it was not also the ordinance that they are relying upon has not been not complied with the provisions that have been enshrined in Article 213, Clause 2, Subclause A, wherein it is mandatory that if an ordinance comes to play, it has to be placed before the Legislative Assembly after the Assembly has reconvened, Your Lordship. It was neither placed and it has lapsed, and basing on that lapsed ordinance, they are seeking to say that the OAPM Act and rules have been repealed, Your Lordship. So my only point of the crux of the matter is this, Your Lordship.
All right. Notice, Mr. Nayak accepts notice for.
Your Lordship, I seek for an interim, Your Lordship. Interim.
No. This resolution is what, of April?
Yes, Your Lordship.
We are already in August, sir. There's no hurry like that. We'll issue notice on that.
If not, it will be construed that the OAPM Act and rule has been repealed by the ordinance.
Anyway, so we have to examine it. It's a legal question. Notice on the IA also.
1, 3 and
1, 2 also, sir.
2. My God, 2 also.
1, 2, 3 and 6. 1, 2, 3 and 6. Notice to the remaining opposite parties. Returnable on 28th September. Replies be filed within 4 weeks, rejoined to the next.
Supplementary list for orders,
Great,
item number
Your
8.
Please, Your Lordship. My Lords,
Yes.
this bail matter on the last occasion, Mr. Katkia had taken an adjournment to file an affidavit.
Right.
He has filed an affidavit that is on record. Mr. Katkia's submission on the last occasion.
Instruction Your Lordship has called for, that is also there. That has come directly to the court.
There's no jail offense.
Why flag? Why English?
Yeah, there is no jail offense.
That is also the tenor of the affidavit which has been filed today.
And plus that I had made a submission basing upon the instruction I had received earlier, which is before Lordship. That start from page 5, Annexure B.
Para 4, Your Lordship may see the affidavit.
Where is the affidavit?
Affidavit dated 8th of August.
Already filed also. Must he filed on 10/8. I'm just using the hard copy.
One copy. Yes.
Para 4, my Lords. It reads like this. From 8 lines from the beginning of para 4, my Lords may see.
Yes.
It is submitted that while furnishing the health condition of the appellant, one and his criminal antecedent, petition filed before the jail authority by the staff members alleging misbehavior of the appellant 1, the fate of which has been resolved after conclusion of the inquiry, as stated under Annexure A, was inadvertently enclosed to the instructions sent to the office of the AG Odisha. It is submitted that the facts of the inquiry and the health status of appellant has no nexus with each other, inasmuch as the allegation made against appellant number 1 was false and baseless and manufactured one. Copy of the instruction contained by letter dated 8/7/2021 is filed and marked as Annexure B. And in para 5, we write second line, as far as the present behavior of the appellant 1 is concerned, it is submitted that during incumbency of the present deponent since 24/2022 to till date, no such allegation and complaint has ever been made before the undersigned, either by the jail inmates or by the staff of the office, regarding ill treatment and misbehavior by appellant number 1.
Yes.
The last week I'll peruse Annexure A.
Yes.
Second paragraph, the last line, my lords, may see of Annexure A. So the allegation is baseless and manufactured.
Yeah.
Instead of treating the inmates with temper, humanity, kindness, strict impartiality, and without irritability, the warders are trying to go against them. And he asks that the allegations may be dropped.
What do you say, Mr. Katkia?
Plus,
We'll hear you after that.
Yes.
Yes.
that is plus virtually, in fact, the letter which has been sent by the official staff of the jail, that is under Annexure B plus.
Yeah.
So that was there with me on the last occasion. So I made a submission that
That's it. That's all false now.
now plus Annexure A, it is made clear that in 2016 there was an inquiry, because all have written to the DG. There an inquiry. After the inquiry, it has been found to be false. That has been closed to us. So now, as per the last paragraph, the present incumbent, the superintendent, that jail, Balangir jail, is saying that he doesn't have. The person is having good conduct.
No. So he has been in jail for how long now? 2.5 years.
From 30th of January 2013, my lords.
13.
Yes, my lords.
It is a case of double murder. And probably written note of submission was filed by my senior in this case.
Lords, it is a case of circumstantial evidence. The circumstance appearing against this appellant, my lords, is an alleged confession made by appellant number 2.
What happened to the other appellants, sir?
4 and 5, your lordship granted bail. My lords may look at order dated 1/9/2021, 17/12/2021. No, I'm sorry. It will be order dated 21/9/2020.
Yes. Yes. 21/9/2020.
Right.
Your lordship has considered that extrajudicial confession in that order.
That's right. Vis-a-vis 4 and 5.
Yes.
Right.
The same extrajudicial confession is the material against this appellant, who is stated to be the prime conspirator. The witnesses are PWs 7 and PW 19, my lords. They have stated that in their presence, a confession was made by the appellant Upin Patel in the presence of the police at the police station. This is a statement said to have been made on 27/1/13, which is dated 23/1/2013, that your lordship took into consideration when your lordship considered prayer for bail of appellants 4 and 5. Lordship may excuse me, I've got a bad cough.
No, so the extrajudicial confession is one of the central pieces of the evidence.
It's the most weakest piece of evidence, as your lordship knows. The confession leading to recovery. The inadmissible parts, my lords, have been taken into consideration.
Yes, Mr. Mishra.
And I have no criminal antecedents that has come out in the trial itself.
There is also last in theory.
Last in theory with regard to Damodar Patel, not with regard to this appellant. Damodar Patel was carrying one of the deceased in his motorcycle. The other deceased was following him.
Yes, Mr. Mishra.
That is the evidence of the witnesses.
May I please, Your Lordship? Lord, so far the present appellant is concerned, he is the main conspirator. Both the deceased, the principal deceased Panigrai and the appellant belongs to two different political factions. And they all dispute arose because of the avoiding the taking the work under particular block, taking PC, collecting PC, all these things, this was going on. And this gentleman, the present appellant, he has a conspiracy by sending that man to call the deceased to a party. And that's a last seen theory that has been seen. And in extrajudicial confession, one of the accused, one of the witness said that while the interrogation was going on by the crime branch, because of there is no direct evidence, circumstantial evidence, the matter was handed over to the crime branch for his expert investigation. And they found the material, they're connecting the conspiracy against the present appellant. Here, your lordship kindly see the evidence of PW2, PW7, PW10. This PW10, who in the trial turned hostile, happens to be a relation of the appellant, who used to stay in a different place, who has stated that the appellant came in 161 statement, not before the court, because he's become hostile because of the relation. He said that he was with a dress, with a bloodstained cloth, and the jeep in which it was dashed, it was repaired there. But he didn't know what happened. So on the basis of that statement, all along the bail application of the appellant was rejected. And he was in custody during the trial. So far the conspiracy is concerned, there is very thin below the material regarding conspiracy. It has been brought out by the crime branch during the investigation. And this 10, 11, and what my friend said, that is PW19. So this all read together will go to show that he is the principal conspirator. He asked one of the co-accused to bring that Panigrai to a feast, and one of the friend of a Panigrai was also, he followed, seeing that accused who has been released on bail, accused taking the deceased to the place of feast. So that is what they saw, the last in theory. And this PW7 and 19, they have stated that the accused, while in interrogation in the police station, he was deposing, he was stating before the police that it was the Pati who directed them to take him to the feast, and thereafter he went to the spot and he assaulted by Bhujali. The detailed evidence, if your lordship will like, I can paste the evidence of PW, that is 7 and 19. So in this background, what I say, since the matter is also old, your lordship may hear the appeal, because at that time the appreciation will be that what is the value of the evidence of that PW10 Koro, who has stated and turned hostile. In addition to the evidence of the two witnesses before whom he made the co-accused made extrajudicial confessions while interrogation was going on, and he led to discovery of the weapon, and the weapons were discovered, and also number plate was also discovered.
No, is it an extrajudicial confession or a Section 27 statement?
No,
Section 27.
no, 27 so far recovery is concerned, but these witnesses have heard, interrogation is going on, it amounts to extrajudicial confession. My submission.
Last in
And
three also. Your also come to page 19 of the judgment, internal page 19. I'm reading last 8 lines.
This Suresh Kaur, what is the evidentiary value of his evidence when he turned hostile vis-a-vis his statement given under section 161 CRPC? That simplicity alone cannot lead to conviction, but that adds to the evidence of the two witnesses, 7 and 19, who has deposed that they have heard the co-accused stating all these things, this conspirator that he
saying it to the police.
Yeah, while interrogation is going on,
just
definitely.
overheard it.
Yes,
See,
yes.
Once you say there's an extrajudicial confession, A should
No,
make
your
it to
lordship
B.
is correct. Your lordship is correct.
Here C is hearing A make it to B.
Yes.
That's
yes.
not extrajudicial confession. That's made to the police anyway.
Man.
So that's not an extrajudicial confession.
Because these two witnesses, after knowing that the person, one accused has been arrested, they went to the police station to find out what are the stage of the investigation is going on.
No, so they overheard. They basically overheard.
The whole point is that in a double murder case, in the nature of this case, the investigation, naturally the direct evidence is very difficult to get it.
No. We are not on that, sir. Whatever is the circumstantial evidence, we're only examining.
Yes, that is the thing. But what I say, my lord, since the 161 statement is there, he was all along in custody, and now he is ended in conviction. If your lordship can be hard on merit, and if he is entitled to be relieved, he will be acquitted.
The paper books are not ready yet.
If your lordship's direction, it can be made within a week. Because now the paper book is not printed, it is now xeroxed. On the last typing sometime in 80s, the printing process was going on. Of course, that was for death reference.
Maybe hard because
this is the main conspirator. Means the main conspirator, and all dispute arose because of this contract, PC, etc.
Now, what about 2 and 3? Appellants 2 and 3? They're also in custody.
2 and 3 are in custody. I have not moved bail for them.
Next they may come also. The whole point is there's a phase wise your lordship knows the professor.
Evidence is not different. Evidence is the same.
Evidence is the same, Miller.
He has utilized all these people to call. Thereafter, he carried some night in his jeep, Gylo jeep. The Gylo jeep was, the accident due to dash. It was repaired at another place that is nearing district Bargarh. The relation himself has stated before the police that there was bloodstained cloth. He didn't know how it happened. And thereafter, after going for repairing with his son, he didn't return.
No. Apart from this recoveries, are there bloodstained clothes of the accused where it contains the blood of the deceased?
None, my lords. Your lordship may see the evidence of the IO, my lords, PW 26.
No. Naturally, he will definitely. He's a very, one of the most intelligent out of the lot. He's a, urban.
I will
leader,
only draw your
urban leader.
attention.
So naturally, when you say after rushing to a place, after rushing to a place, he will not keep it for the recovery of the police.
He has been in for 9 years now.
Madam, that is correct. The whole point is that since your lordship who are in custody, sometimes your lordship hears in priority, your lordship may hear in priority. In many cases, also your lordship hard on merit.
I am not asking for priority here.
Did I say that you have asked for it? It is my submission. I didn't say that appellant asked for it. This one not my submission.
Tell us about the deceased. There are 2 deceased, right?
Two.
Both
They were called to a feast, and when they reached, they were mercilessly attacked by the present appellant as well as his henchmen, who are the co-accused. And with much difficulty, the crime branch detected the conspiracy as well as some evidence relating to the weapon of offense, and also one statement, the witness who has gone torn hostile. That is Kaur, because of his relation. He admitted that he is a relation, but he disowned his statement. That is Suresh Kaur, PW 10.
Jury is at page 11, paragraph 15.
Page 11.
Page 11 was paragraph 15 of the judgment. The injuries.
How far the evidence
Right,
of this PW 7 and 19, which ultimately
20
in a
CM.
case like this of murder with conspiracy in absence of a direct evidence can be taken into consideration to prove the case of murder. And a lot of pain has been taken by the crime branch to find out this matter because it's a well-planned and well-hatched.
I have
Murder.
voluntarily surrendered to custody in the lower court, my lords. Crime branch never arrested me, never took me into custody even.
Was there any alternative? You are the prosecution case, your lordship, the entire thing arose out of the fight because to get the contract, to allot the contract, to collect the PC, both are. One belongs to X party, Y belongs to X
all statements which are being made without any materials in support thereof. Mr.
Probably
Mishra is making statements out of his hat.
Probably copy was served to you in the trial court. The written note of submission, it is there very much.
Sir, Mishra, written note of submissions cannot overweigh or outweigh evidence recorded.
Did I say that it overweigh? I said that it is there on record. By way of submission, keeping in view of the entire prosecution case, evidence materials on record. You didn't dispute that by filing a.
My mistake.
1 minute. This appellant. No, the last scene is not with this appellant.
No, my lords.
No,
It is
that is,
a
that-
capital number.
That is Putel.
That
But this being a very sensitive case of that
PW 19,
particular
my
area,
lord.
it is a case of double murder. But my land is suggesting for early hearing of the matter. So
PW 19 evidence for a moment, your lordship, can
I
see.
appeal to Lordship Judicial Consists for that.
19, the evidence, because if your lordship allows, I can place the evidence of PW 19. Upon stated before the police in his presence that the murder of the deceased persons was planned by accused Joyprakash Pati, that is present appellant, and on his instruction, accused Damodara arranged the feast by calling both the deceased persons to the feast and after arranging the feast to call him. And their evidence is not demolished. The whole point is that why they will speak against the appellant. That has not been demolished. Your lordship, kindly see the evidence of PW 7 and 19. They just as a co-villager, there was a murder, a sensational murder of some person known in the locality. They had been to the police station that on hearing of one accused has been arrested. And your lordship, kindly see the cross-examination also of these two witnesses.
Paragraph 11 of the cross-examination of PW 19, your lordship may see.
That is to be seen as a whole.
No, let para 19 be seen that they are simple villagers. It is a fact that I am working as SCM under Chandan Bhatti Panchayat. At present, Vijay Kumar Panigrai, elder brother of the deceased, is the Sarpanch of Chandan Bhatti GP. I cannot say whether Vijay Panigrai was also the Sarpanch earlier. Vijay Panigrai Sarpanch is the elder brother of deceased Badababu. This is what this witness has admitted at para 11 of the cross-examination.
The entire evidence can be seen. Your lordship, can see a full gentleman, they never go. Somehow the little bit interested, having a political leanings or liking or the anxiety or the having useless time, they used to see. The whole point is that if your lordship will say, permit me for a moment, around 20 to 25 years back, when this 4-lane road was going on construction, I was going to Bhubaneswar at one point of time. And I saw around 300 to 400 people standing on the bridge of Katjodi. I thought that something must have miraculous has happened. And when I found that what has happened, why the people are there, they are witnessing a earth remover. So unless they have got that useless time, they will not see a earth remover, hundreds of people. So this is our nation, this is our circumstance. Somehow or other the people are little bit either interested or known or something, they are going. But the whole point is that it is open for them to demolish the evidence. If it is demolished, then it's gone. If the evidence of PW 7 and 19 are demolished, it is found to be, then you will have a clean acquittal. Around 300, 400 people were observing a very big earth remover.
And since you also stopped, you probably had useless time. Maybe.
No, I thought that you might be there. I thought that you might be there for trial. That is because might be going there for.
Yeah, I don't have time to waste. Like
Who knows? You didn't give us your catalog where you are to utilize your time or waste your time.
as though you gave your catalog.
No, neither of us.
Lord,
It's all right. We're just digressing now.
It's all like
We're now
a-
digressing. Yes.
I draw your lordship's attention to the cross-examination of the IO PW 26,
Yes.
paragraph 29, my lord's missing.
Right.
He says, by the time I reached at the spot, I found a huge gathering. I have not examined any person from the gathering except the scribe during my spot visit, prior to inquest. During spot visit, I found 2 Nokia mobile phones lying at the spot, of which one was lying in the pant pocket of Minoketan Gibela, and the other was lying near the dead body of deceased Dibyajit Panigrai. A court summons was also found in the pocket of deceased Dibyajit. I have not left those properties at the spot. I have not seized those properties. I cannot say the whereabouts of the said properties. I cannot say ownership of the said mobile phones. One was lying on the pant pocket of deceased and the other was lying near the other deceased. I cannot say any specific detail of the summons found from the pocket of deceased Dibyajit. Except seized properties at the spot, I found no other incriminating material there. I left the spot at about 1:30 p.m. Then para 31, he says he made effect seizures of everything except these material evidences. This is how the investigation has
Well,
progressed.
my submission is that if it was so easy a case, he has thrashed out all the courts. I don't know about the Supreme
One minute,
Court.
let me just finish, sir.
My further submission before your lordship is that with my little knowledge of the law, my lords, I know that a statement made before a police reading to recovery, my lords, implicates only the maker of it to the admissible part thereof. And the inadmissible part thereof cannot be used as evidence against any co-accused. I'm not sure the law might have changed, like the law has changed now, to allow informant's counsel to make any submissions that he chooses. But if that is the law, my lords, can a confession made by a co-accused, which led to recovery of a tabli,
So which of the co-accused made the Section 27 statement?
in Patel, my lords?
I
Your
see.
lordship has discussed that evidence while granting bail to appellants 4 and 5.
4 and 5. All right. All right.
Any material has been collected by the police with regard to the rivalry between both the sides
Nothing, my lords.
and the deceased Bodababu?
Nothing, my lords.
Rivalry at the workplace.
Rather, the brother of the petitioner has himself stated that both were also taking tenders together, the elder brother of the petitioner. My lords may see the evidence of the elder brother, Vijay Kumar Panigrai, cross-examination at paragraph 8, what he says. Accused Joy Prakash belongs to BJD party. I don't know whether Joy Prakash contested for vice chairman post. He is now the vice chairman of Loisinga block. I do not know whether Tonkadhar Gadtia was the chairman of the Congress. I do not know whether Tonkadhar defeated a Congress candidate. And then he says, my lords, I went to Sadar PS Balangir only once on being called by the police. I cannot say when I went to Sadar PS Balangir for the second time. Another brother is Bharat Chandra Panigrai PW2. his evidence is paragraph 3, deceased Badababu was a contractor. He was doing contract works at Loisinga. I know that accused Badababu had a quarrel with accused Joy Prakash. I was examined by police of Sadar PS Balangir and by the crime branch in connection with this case. And para 7 years stated, I have not stated before the crime branch that this is Divyajit alias Badababu was forcibly taking PC from government officials. Those who were not giving PC was threatening them. It's not a fact that I have stated before crime branch that deceased Badababu was making tender fixing. Then, my lords, another brother, my lords, another person, Raghunath Panigrahi, he is PW6. He says that on 16/1/13, paragraph 2 at 5 a.m. in the morning.
Mr.
my
Konda,
brother- My lord.
any of the call records vis-a-vis the appellant
No,
have been
no.
so as to
Nothing,
show that there is a connection with
Nothing,
other
my lord.
appellants?
My lords, those phones were never seized by the IOPW 25. He did not seize the phones of those deceased. They were never produced anywhere, my lords.
That is why my submission, my lord, not the piecemeal reading by for the bail. Without any material, how can it be presumed that the land session judge has convicted him? If it is so simple a case, first of all, he would have been granted bail during the trial. He was not granted by this court or the lower court. And there, after the hearing, they have been convicted. And the piecemeal reading will not give a clear picture. If your lordship want that, I can place the entire evidence. That is what my submission, if your lordship so pleases, may keep it for next week or next week for hearing. Because he is reading piecemeal, I am not able to place my piecemeal. Reasoning given by the land session judge on the evidence of this thing, then it is found to be illegal, unacceptable. Then the appeal has to be allowed.
All right. All right.
So
Orders reserved. Orders reserved. Right.
Obliged.
because the reason given in detail and also minute so far the materials evidence are concerned.
All right. Orders reserved in the bail application, IA 978 of 21. Right.
Supplementary fresh admission item number for orders item number 9.
Item 9, my lord, the defect was removed on 5/7/2018, my lord.
All right.
My lord,
I know it still says not removed, but anyway, tell us what the matter is about.
my lord, what I pray, my lord, there are 7 other cases. The lead case is 9266 of 2016. There a counter has been filed by the state. May I pray, my lord, all these 7 matters be tagged with this, my lord. Because the important page is 33, the neat copy I have filed, that was the defect. And that was not before lordships. My lord, may I pray, my lord, all these 7 matters be tagged with this.
Judicial service, is it?
Page 33, my lord. Page 33, the neat copy was to be filed. Because some portion of right hand side
All
of
right. List along with those 7 matters.
my lords, I'm giving the slip, my lord.
On 14th December.
9266 of 2016 is the lead case, where a counter has been filed by the state.
All right.
Supplementary list item number 10.
May I please? Here the revenue has challenged the order of the tribunal and frame the question is running page 8 of the appeal memo.
No,
Whether-
the other side served.
No, my lord, this question has already been admitted in earlier cases.
No. So let's issue notice now.
Yes, Your Lordship. No, this question has already been admitted in the other appeal of the present petitioner. I am placing the just hand it over the. But there are A to C here. Only A is applicable here. There are some other questions also there.
But even there, has notice gone?
Yes, my lord. Notice gone.
Just say notice list along with ITA 4 of 2019 on 12th December.
Miscase may be allowed. So, dispense with the filing of annexure
Yeah, miss cases allowed.
2 and 3 may be dispensed with.
All right.
Supplementary item number 11.
My lord, I submit from DC, my lord.
Yes.
My lord, it is for dispensing with annexure 2 and 3, my lord. Flag A.
Yes.
Well.
Tell us, sir, what's the matter about?
My lord, this is a sole proprietor business, and his business is doubted based on the case sales, and the assessing officer issued notices to suppliers for verifying the purchases, and 133(6) notices were issued, and confirmations were received by the assessing officer. But before that, he had passed the order. And in the appeal also, they had not told about this fact that they have received the notices in the commissioner appeals, and also in the ITT appeal also they did not submit. And thereafter, we got by certified copy, that is annexure 5. Annexure 5, 133, my lord, page 57, my lord, may kindly seen.
Yes.
Yes, my lord. These are the 3 suppliers. These notices were received by them on 6th April 2015. But before that, the assessing officer had passed the order on 27th March 2015. But even after getting that, they did not change their order. Also, they did not submit that fact before the Commissioner of Appeals on 17th 11 2016, and also in ITT appeal. They suppressed this fact, and they said that the purchases from the suppliers are still not verified, even if they had the documents annexure 5.
All right. Just say notice. You who's paying it? 7 December.
Supplementary item 12.
Item 12, I'm filing my counter affidavit.
Item 12, my lord, I have filed, see my lord, last order, dated 11/7/22.
Yes.
I am filing the amendment petition, adding the parties, necessary parties, as well as the person who are who have encroached the.
You filed requisites for 3 and 4, sir.
Well, my lord,
You have not filed requisites for 3 and 4.
3 and 4.
Opposite parties 3 and 4, you had to file requisites.
My lord, I will file it tomorrow. And the IN number 10611022, you also can take off that.
All right, 10610/2022, for the reasons stated therein, the application is allowed. The consolidated representation, have you already filed or you are going to file?
My lord, I am filing the consolidated petition. Consolidated.
Not like that, so you have to file it in the registry. You have to give him a copy. Consolidated petition be filed within a week. The reply of opposite party number 2 is taken on record. The petitioner is permitted to file a response thereto before the next date.
Well, we'll file an additional.
An additional. The opposite parties are permitted to file an additional reply to the amended counter writ petition before the next date. 13 December.
Great. Supplementary list item number 13.
Please, my lord. My lord, here the state government has declared 314 Odisha Adarsh Vidyalaya, whereas the present petition also representing serial number 36, Lahanda. My lord, the entire exercise has already been completed. So other places where the school has started functioning. But here, I don't know why since 2009 we are in 2022.
You have a representation.
Yes.
All right. The petitioner's representation. What is that issue? You have delivered it.
Annexure 5, RDC also communicated a letter to the collector concerned that we have to take initiative immediately to take admission of the students. Annexure 5 is there. RDC North Division.
The petitioner's representation, bracket Annexure 6. There's already an earlier representation, Annexure 4.
Yes.
All right. Be examined by the Collector Bargad, and after notice, the petitioners as well as opposite party number 6. And after giving them a hearing, a reasoned order shall be passed not later than 14th November 2022. The court clarifies it has not expressed any view on merits. The petition is disposed of.
Oh, my lord.
Supplementary list item number 14.
May I please, Your Lordship? In item 14, my Lordship, on last occasion, I have took time to file an affidavit. But some of the petitioners have not turned up, so I have not filed the affidavit. So I will be permitted to place this matter without the affidavit, Your Lordship.
Okay.
In this contempt application, Your Lordship, the petitioner has filed the alleged for the non-compliance of order dated 6/7/2010, Your Lordship.
2010?
My Lordship.
What are you doing in filing it in 2011, is it? You filed? All right.
Yes, Your Lordship. The case of the petitioner is, my Lordship, on 2002, there was an advertisement by the Odisha State Housing Board for allotment of 6 number of duplex core houses. The petitioners being an applicant, they have applied for the said plot by filing their application as well as the application fee of with 1.5 lakhs. Now, because when the in the 2002, my Lordship, I kindly mark that when they have not allotted us the core houses, then we have turned before this honorable court. This honorable court directed that if there is no impediment on their part, the said core houses be handed over to the petitioner. Now, should kindly see order number 5. It is 6/2010, Your Lordship, in WPC number 13238/2008. That I have enclosed in a contempt case number 264/2011, Your Lordship. Your Lordship, permit, I'll just place that operative portion of the order.
Yes.
All the 3 applicants, in pursuance of an advertisement issued by the Odisha State Housing Board on 28/12/2002 for allotment of 6 number of duplex core houses, submitted the applications along with earnest money deposit. A lottery was conducted on 7/5/2003 in the conference hall of the Odisha State Housing Board at Bhubaneswar, and 6 persons, including the present 3 petitioners, were selected for allotment of 6 number of core house. The proceedings of the lottery conducted on 7/5/2003, but Annexure 2 shows that all the 3 petitioners had been allotted with house number 1, 2, and 3 respectively in the said lottery. Thereafter, they were asked to deposit the required lease premium, and it is stated by the learned counsel appearing for the petitioners that all the 3 petitioners have deposited the lease premium. The grievance of the petition in this application is that due to some encroachments over one of the said plots on which core houses have been built, position of the same are not being handed over to the petitioners. We find from annexure attached to the petition that orders have been passed for removal of the encroachment, and help of police has also been sought for wide annexure 6 to remove the encroachment. However, the encroachers have not been evicted as yet. From the map submitted by learned counsel for the petitioners in course of hearing of the application, we also find that the encroachment is in respect of core house number 6, and there is no encroachment so far as core house number 1, 2, and 3 is concerned. We therefore dispose of the application directing the opposite parties to take immediate steps for removal of the encroachments and hand over position of the core houses in question to the petitioners and other 3 persons who have been selected in the lottery, subject to fulfillment of all the criterion, preferably within 3 months from the date of communication of this order. In the event it is not possible to evict the encroachers within the opposite time, the State Housing Board shall find out as to whether the core house number 1, 2, and 3 allotted in favor of the petitioner are free from encroachment. In the event as indicated in the map, if the said core houses are free from encroachment and there is no legal impediment in handing over possession of the same to the petitioner, the same shall be done within the official stipulated period. Pursuant to this, my lordship, after the stipulated time period, I filed this complete content application. Now, on 11/7/2018, they have filed a show cause affidavit, your lordship.
Yes.
The specific stand of the State Housing Board is, my lordship, the aforesaid 6 plots, one private party, he was in possession of the said suit land, and he has filed a suit before the Learned Court Bhubaneswar, Trial Court Bhubaneswar, your lordship. Now, my lordship, may kindly see page number 101 of the said affidavit. It is the form of order sheet in the Court of Second Additional Civil Judge, Senior Division, Bhubaneswar. In IA number 1 2018, arising out of civil suit number 636 of 2002, your lordship.
Where are the IAs? I don't find. It is not bookmarked. IA 822.
No, this is show cause affidavit, my lordship. The show cause affidavit filed by the Odisha State Housing Board. That is that.
That's there. Show cause affidavit.
Yes, your lordship. Flag A.
Yes.
Page number 101, your lordship. The specific case of the Odisha State Housing Board is, despite all their endeavors, they are still not able to take the position of the property, your lordship, of the 6 plots, to which I am concerned. And that order has been passed way back in the 2018, your lordship. The civil judge, Senior Judge Bhubaneswar, he has passed an order of status quo, your lordship, of the said suit plot. Now, as far as my instruction is concerned, my lordship, that suit has been disposed of, subject to what the.
But you have to file an affidavit for all that, no?
Yes, your lordship. That I agree. But because the petitioners are there,
because
all
these are factual details, they will not even be able to verify.
Perhaps, my lordship, the counsel for the Odisha State Housing Board should answer that.
Yes, my lord. May I please, your lordship? My lord, I am in virtual mode, my lord. I filed this detail. These are the difficulties, my lord. Though
you have to unmute, sir. You have to unmute.
Though, my lord, we have taken possession of this land for development purpose, for making commercial and residential houses, but it was not possible till 2019, my lord, because of several litigations pending in different courts. We have taken all necessary steps, not only we, the government agencies like J Department, BDS, and police authorities, all their efforts were in vain, my lord. Ultimately, we have taken a decision to recall that scheme because it is not viable for proceeding with this scheme, my lord, because of lot of changes in the meantime and lots of time, my lord.
You have to file an affidavit then, sir.
Yes, my lord. This is the recent development. I will file, my lord, within a week. Your lordship may grant me time.
Counsel appearing for the Orissa State Housing Board seeks and is granted time to file an additional affidavit, bringing on record the latest developments. Likewise, Mr. Biswal, appearing for the petitioner, states that he too will file an affidavit for the next date. 14th December.
Grateful, your lordship.
Supplementary list item number 16.
Yes, my lord, it is illegal construction of the Chigudi garage, prawn pond excavated.
2 o'clock. We are taking at 2 o'clock.
2 p.m.
2 p.m. Achha.
Supplementary list item number 17.
17 my lord, by order dated 25th April, your lordship had directed to file counter within 8 weeks. Oh, for till date.
Or last
My lord, in this case, I am appearing for the opposite part number 1 and 2.
Today I have received the Parawise comment. 15 days required for filing the.
Counsel appearing for opposite parties 1 and 2 states that he will positively file the reply affidavit on or before the 29th August
My lord.
2020. Rejoined for the next date. List on 19th October, sir.
Supplementary list item number 18.
My lord.
Item 18.
In this case, I have received the instruction, my lord. I will be filing countervail next week, my lord.
Or she's right now sitting here. Mr. Mahapatra states that he will file his reply within 2 weeks.
I have already informed.
Or interim order to continue list on 29th November.
Supplementary list item number 19.
Item 19. My lord, last occasion, your lordship directed to file counter. Counter has not been filed. Some more.
Last option to file counter within 8 weeks. Rejoined the next date.
My lord, in this case, I am appearing for the 14, 15 and 17. My lord. Copy number 14, 15, 17 and 20.
13th December.
Supplementary list item number 20.
20. These are the matters may be taken up at 2 p.m. because all are related to that prawn matter.
To 2 o'clock.
Right. 21 also.
21 is.
Sorry, sorry. I'm sorry.
22.
21 also.
Yes, my lord.
All right.
Supplementary list item number 22.
I may pardon you, let's say item 18.
We continued the interim order.
My brother, he's saying that on 16th, your lordship may
29th, 11th.
next week 16th, he's filing counter. So it is a very small issue. Only 1,60,000 is the unexplained amount. As per the act, below 2.5 lakhs, there will be no proceeding. And the amount is very small, 1.6 lakhs admitted. So,
all right. When do you want it?
16th of next week.
Next week? No, he won't. He'll file his
Today is filing. Next week. So your lordship may fix a date.
It's all right. Let it come on 29 now.
Oh, blessed.
All right.
Supplementary list item number 22.
May it please the lords. My lords, this
counter
is
rejoined and not filed, sir.
Counter has to be filed. This is a case, my lords, will kindly remember 240 mentally handicapped children in a shelter home.
Correct.
I have applied for the renewal of the foreign.
CRA, correct.
My lords, for no reason under Annexer 1 at page 20.
No, we already issued notice, I thought.
Notice on both. Writ petition as well as miscase. Now the Union of India is to file its reply.
Who's appearing? Who's appearing for? Mr. Gochayat appeared last time.
Yes.
Should we pass it over because he's not here? All right, pass it.
Supplementary list for hearing item 23.
May it please, my lord. I'm appearing on VC on behalf of Mr. Debashish Panda, my lords. I pray the matter may be taken up after lunch, my lords.
All right.
Oblige me.
Supplementary list item 24.
Same problem. They don't come. What we do? Should we rise and come back or you call the council, I think. Otherwise, it's just going to be passing over and is anyone here from
Supplementary list hearing matter.
Item number 27, Melo.
Tell us about this.
Item 27.
Who's for the other side, sir?
Mr. Mohanty was appearing, Mr. Raghu Raghuban was appearing. Mr. Raghuban should be online. I don't know, I just inform him so that he can join.
Oh, I see. Please join.
Supplementary list item 27.
I just inform Mr. Raghavan.
My lords, I'm speaking on behalf of Mr. Raghavan. My
Yes.
lords, may kindly pass over the matter, my lords.
All right, all right, all right. We'll come back, I think, 12:15. 12:15 will come back.
My lords, item 25, my lords, I'm here on behalf of Mr. Debashish Panda.
Yes.
My lords, on the last occasion, the State Council was to file a reply with regard to the maintainability for 302 read with 149 in case when whether it is applicable.
No reply. He is just to make his advanced submissions.
Yes, my lords.
May be permitted to argue this matter. I may be permitted to argue that matter.
No, but he's not there. Mr. Panda is not there.
Yes, please. Yes.
We'll come back at 12:15.
Yes.
I'm sorry, my lords.
You're here. Good.
My lords, I came just to make a mention. I'm examining a witness, my lords. Therefore, I asked for item 21 to be taken up after lunch.
Okay.
And this matter also.
All right. All right.
And what I was praying is that if item 21 is called next week, my lords, it would be more convenient for me. Because if I start, I cannot finish it.
No, we don't want to keep it parted or anything, sir.
It's not patterned. 21 is not
item 23, not 21. 23. So 23. Past item. 23.
Yes, 23 is not patterned.
No, one of its 25 is parted.
25 is parted. I'll do that after lunch, my lord.
All right.
23 may be taken up next week.
All right. 23 is already a 2000 matter, sir.
Yes, my lords, I know that. But since it will not finish, why unnecessarily we'll keep it parted? I'll do it next.
All right. All right. We'll stay on board.
Lovely.
We'll just keep it for next Thursday.
Right. 25 past 20. Item 20.
Let's
18 is a holiday.
seek your lordship's kind indulgence. Let's seek your lordship's kind indulgence. Mr. Raghavan is appearing in this matter on behalf of the respondent. He just called me and quite.
He's in some difficulty.
Yes, my lord. He is placed in the High Court at Karnataka. So
correct.
My lords, I apologize, my lords. I'm appearing on behalf of Sri Ravi Raghavan. He's on his legs, my lords.
I know. We are just told. So we'll have it on some other day. Mr. Ravi Raghavan, learned counsel appearing for the respondent, is in some personal difficulty today. When does he want it? When will he be free?
That's any time which is convenient to your lordship.
My lords, next week.
That's what we've got too many holidays next week. That's what. September. Take a chance of 15 September.
Oblige, my lords.
All right.
My lord, can it be on 14th?
No, that's the problem. So, 22nd September. 22nd.
Oblige, deeply obliged.
Oblige, my lords.
Make one sealing. Item number 24, supplementary list.
Lordship, item number 24, I may be pardon your Lordship. On behalf of Miss Mishra, Lordship, Miss Mishra has faced an accident, so she is not unable to appear in before your Lordship. Lordship, I may be granted a week time for this. She will appear in this matter, your Lordship.
All these are very old matters. And please, this
Yes,
is what started, I think. We made some submissions in this last time. Last time she had started arguing it.
Yes, your Lordship.
But she has met with an accident also.
I know. So let's say 25th. Yeah. 25th. Will she be ready all right by 25th?
Yes, your Lordship.
Supplementary list item
25th. Urgent to 25th loss. And also 23.
Yes. Because next Thursday is a holiday. So.
Yes.
Item 25 passed over. Item number 26. Supplementary list item number 26.
Who's the lawyer here? His brother had expired, and so last time there was. Mr. Raut is there.
Twenty-six. My lord, item 26. My lord, I will collect the paper book today, my lord. Your lordship may fix up any day next week, my lord.
Mr. Raut states that he's collecting the paper book today and prays for an adjournment list on 25th, right?
25th August, my lord. Obliged, my lord. Deeply obliged.
Supplementary list item number 28.
May I please?
Yes.
I'm appointed through Legal Service Committee. The appellant has been convicted under section 302 of the IPC and sentenced to undergo imprisonment for life, my lord.
Yes.
And to pay the fine of rupees 500 and to undergo arrival in default to undergo arrival for 6 months. The learned trial court has convicted the appellant only basing on the statement of the PW2, the eyewitness. If the eyewitness basing on his statement, he has been convicted by.
2 and 6, both are eyewitness.
6 is not the eyewitness, my lord. He's a post-occurrence eyewitness. My lord, 6 PW2 stated that after he made a hula that the appellant has gave successive blows to the neck and beheaded him. Thereafter, the PW4 and 6 arrive at the spot. So the sole eyewitness is the PW2. My lord, that is our second, my lord. He is the sole eyewitness.
All right, orders reserved.
My lord, only I think I want to submit, my lord, there is no motive.
When there's direct eyewitness.
My lord, I admit that.
We'll corroborate the medical evidence as well as the scientific evidence.
All right. He's not on bail, no? He's in jail.
Jail.
He's in jail.
My lord.
All right.
And he's a tribal people, my lord.
Whatever, sir.
Considering the period of detention, my lord may take a sympathetic view.
No, it's life sentence, sir, anyway. So.
And also the disease had with a tangia, my lord.
That's all right. He's not on bail, right?
No, sir. My record is not clear. Because it is order series since 5/12/2019.
All right. Orders reserved.
Supplementary list item number 29. Item number 29.
They're all waiting for water.
That matter, my learned senior Mr. Khurshid was appearing on the last occasion.
This one, no?
Yes, please.
He is in fact connected. Yes, Mr. Khurshid is here.
Here, well, it's your lordships had indicated that the other side will respond to it. And then if we had something more in a very short rejoinder, we would.
Right.
Go there.
All right. He's here.
No, sir, 4 appellants have been convicted. The question that has been raised by my learned senior on the last occasion is because only 4 persons have been convicted. So it cannot be a case under section 396. It cannot be a case under section 395. So ultimately, at best, it can be a case under section 302, or there being no mens rea, that may be converted to 304 part 2. That was the submission advanced by my learned senior in a nutshell. Plus, I am taking lordship to that part of the judgment at page 151 of the paper book. It's a clean case of dacoity. And I will show the judgments where even if 4 persons have been convicted, but other persons are absconding. When record shows that other persons are absconding, and there are more than 5 persons in that particular case, then in that case also, that can come under section 396. It cannot become under section 302. It is a case of dacoity.
No. Is the unknown persons absconding is different?
Unknown persons absconding. It is question is how many persons are there? Whether more than 5 persons are involved in the commission of the crime or not. If there are more than 5 persons, if 2 absconding, if 2 unidentified, then in that case, section 395 will come into operation.
Let's see that.
Yes, please. In TI period, all the 4 persons have been identified.
Where are you reading, sir?
Yes. It is
first judgment, Ganeshan.
That is plus Raja versus State. Plus, you'll also come to my written note of submission. That is page 8. I mentioned that part. Plus, I'll take you lots to that part again.
Yes.
So, from the aforesaid evidence, it's crystal clear that 4 appellants or dockets participate in the commission of crime among the 6 dockets, and there is nothing to disbelieve the testimony of aforesaid witnesses. On Supreme Court, in the case of Raja versus State, reported in 2020-15 SEC 562, held that there is no hard and fast rule about the period within which TI period must be held. That is regarding TI period. From the arrest of the date of arrest of the accused. Further held that once identification of the accused person are fully established, conviction can be sustained. Then in the next page, that is important. Honorable Apex Court in the case of Ganeshan versus State of Republic by Station House Officer reported in 2021 SEC Online Supreme Court 1023. Even there are concurrent findings recorded by all the courts below that 5 persons were involved in committing the offense of robbery merely because some of the accused absconded and less than 5 persons came to be tried in the trial. It cannot be said that the offense under section 391 IPC punishable under section 395 IPC is not made out. What is required to be considered is the involvement and commission of the offense of robbery by 5 persons or more, and not whether 5 or more persons were tried. Once it is found on evidence that 5 or more persons conjointly committed the offense of robbery or attempted to commit the robbery, a case would fall under section 391 of Indian Penal Code and would fall within the definition of dacoity. That is the latest judgment.
Yes.
So, in this case, I'm just drawing lots of attention to page 151 of the paper book. Plus, all these 4 appellants who have preferred independent criminal appeals all have been identified in the TI parade. And plus, I'm reading para 76. From the above discussion, I hold on 23rd February 2007 during noon, the occurrence took place in front of LI's office Bhadrak at Bonchak. Accused Lambu alias Chandramohan Jha, Amit alias Gulu alias Amitabh Kumar, Chunu alias Chuni alias Mohan Chaudhary, and accused Chandan Kumar Sharma along with 2 others conjointly have committed dacoity of cash of rupees 24 lakh and some odd of Central Bank of India, Bhadrak branch. During occurrence, accused persons were illegally possessing firearms like revolver, country-made pistol, and used the same, causing death of Dibakar Sahu and Lalmohan Singh, because 2 persons were dead. Accused persons also caused firearm injury to Kirtan Kuntia, Sanat Majumdar, Arpita Mahanti, and Bijay Barik, who are standing nearby, because they have also been, because it's clandestine firing, all have been injured. The above named 4 accused persons were correctly identified by the eyewitnesses during TI parade and in court. Accused Amit alias Gullu alias Amitabh Kumar, Chunu alias Chuni alias Mohan Chaudhary, and Chandan Kumar Sharma were apprehended by the police from Hotel Sagarin at Charampa. Accused Chandan Sharma was staying at Mr. Guest House at Charampa prior to 2 days of the occurrence in the name of Rakesh Kumar, and he left the guest house just prior to the occurrence. Police seized the weapon of offense, revolver and country-made pistol used at the time of occurrence. Prosecution failed, here look, this is the catch. Prosecution failed to establish the identity of 2 other accused persons present during the occurrence, along with the above named 4 accused persons.
Where are you reading exactly? Where are you reading from?
Plus, I am from the judgment, that is internal page 85, running page 152.
Of this, of our case?
Yes, plus. Judgment.
Right.
Finally, the London Trial Court has held that these persons, for such and such reason, have been found guilty. Running page 152, internal page 85, plus.
Right.
Plus, 2 lines from the top. Prosecution failed to establish the identity of 2 other accused persons present during the occurrence, along with the above named 4 accused persons. Since 2 of the other accused persons are still absconder, so the non-identification of 2 other accused persons no way affect the prosecution case about the involvement of 6 persons during the occurrence. As I hold 6 persons are present at the time of occurrence, so all the accused persons are conjointly liable for the offense committed in this case. Therefore, I hold prosecution able to establish the offense against Lambu alias Chandramohan Jha, Amit alias Gullu alias Amitabh Kumar, Chunu alias Mohan Chaudhary, and Chandan Kumar Sharma. With abundant caution, the London Trial Court has held these 4 persons guilty, though several persons have been tried in the offense, because who have been identified correctly, and only those persons have been convicted. So, in view of that judgment, so more than 5 persons are there in that assembly, though 2 persons have not been identified by now. So, section 395 comes into operation. If section 395 comes, so section 396 comes into operation, because 2 persons have been killed in this incident and 3 others have been injured. And rightly, next, I am reading the paragraph 77. In the result, I hold accused Hushikesh Das, Lakwinder Behra, plus some Chanda alias Sheikh Hafizuddin, Mir Lali alias Mir Ali, Master G, Sunil Kumar, and JP Jai Prakash, Kumar Sharma not guilty. I further hold accused Mintu Dharmendra, Vivek Kumar Sharma, Rajiv Sharma, Sanjit Tura, Sanjeev Kumar, Vivek Vikram Gupta, Krishnananda Behra not guilty under section 120B and acquitted them thereunder. But I hold Lambu, Chandramohan Jha, Amit, and these persons have been convicted under section 395, 396, 397 of IPC, under section 225 of 27 of the Arms Act, and accordingly they have been convicted and sentenced as per the order of sentence. If your lordship will permit me to go into details of the matter, because that has not been placed for your lordship, because there are evidence plus one injured eyewitness there, PW10, who is Sanat Kumar Majumdar, that your lordship get the evidence at page 581. 581 was.
Yes.
No. I'm directly going to paragraph 3. The occurrence took place on 23rd February 2007. On that day, I was driving the esteemed vehicle as the driver was on leave. On that day, I reached at Central Bank of India at about 10 a.m. along with the vehicle. One security guard, one clerk of the bank, and one peon came by the esteemed vehicle from the bank to railway station. They have carried one tin box with them. At railway station, the bank staff collected the cash from me. From there, we came to LIC office branch at Bonchok. In front of the LIC office, in between the road and office, I parked the vehicle on one side, and the bank staffs entered into the LIC office along with the tin box containing cash. The security guard of the bank was carrying a gun with him. About half an hour to 1 hour, the bank staff returned from the LIC office by carrying the said tin box with them. All the 3 bank staff were ahead of me from the side of the LIC office, and I was following them. At that time, I heard the sound of firing. On the backside of my vehicle, one person
was assaulting.
Assaulting the security guard by the gun of the security guard. Seeing the incident, I ran towards the LIC office. One person fired shot towards me, aiming at my head, and I moved my head to the one direction and show my hand, and the bullet hit on the palm of my right hand. Thereafter, I became unconscious. I regained my sense at DHS Bhadrak, and from there, I was referred to Cuttack Hospital as the doctor of Bhadrak advised for amputation of my finger. The doctor SCV at SCV Medical College, Cuttack, also advised for amputation of my finger, for which I was treated at Ashwini Hospital. I was treated at Ashwini Hospital for about 10 days. Due to hit by bullet injury, my ring finger of my right hand became short. I am unable to work properly. I can identify the person who fired aiming at me. The witnesses identified the accused Chandra Mohan Jha, one of the appellant fellows, present in the dock, touching his body. The said accused Chandra Mohan Jha fired the shot aiming towards my head. And it is so claimless, it has not been demolished. And you'll also find at paragraph 11 on the next page, at page 583. I had no earlier acquaintance with the person to whom today I identified in the dock. The witness volunteers earlier during TI period, I have identified that person. Then was paragraph 13, the magistrate told me to identify the person who fired at me, and I identify accused Chandra Mohan Jha during TI period. I have not stated for the magistrate for what reason I identify the accused. And it has not been second. And paragraph 15, the TI period was conducted on 5th of April 2007. So there is a TI period duly corroborated by the state evidence of the magistrate who has been examined as period of 24. And this person is identified, and he is an injured eyewitness. Then I am taking lordship to eyewitnesses who are present there. That is PW 1, 2, and PW 4, and also PW 7. The lordship will get PW 1, that is page 541.
Yes.
Plus, I've also got it. Plus,
yes.
Plus, paragraph 3. I'm reading from the occurrence took place 2 years back during the month of February, in between 12:30 p.m. to 1:15 p.m. At that time, I was present in my shop. On that day, at about 1:15 p.m., I heard the sound like cracking of 3 to 4 times, and in order to know the occurrence, I looked towards the LIC office and saw one person has caught hold of the security guard of the Central Bank in front of the gate of the LIC office. Another person was assaulting the security guard by the backside of the gun on his head for 3 to 4 times. At that time, one person went away by carrying a tin box, and the person who was assaulting the security guard whirled the gun and was abusing in filthy language and was saying, that means if anybody interested to come nearby me, you come. So that accused Amit was saying so, and thereafter accused Amit fired shot Amit is one of the appellant laws. One towards the sky and the other shots on different directions, and one bullet shot one barber on his belly. At that time, another person is by a two-wheeler and accused Amit sit in the said motorcycle and fired shot to different directions and left the place by the motorcycle. Accused Chandan has caught hold of the security guard from his backside. Plus Chandan Sharma is one of the appellant. Then I am reading paragraph 5 plus. About 6 months to 7 months of the occurrence, I have attended the TI parade conducted inside the Bhadrak jail. During TI parade in presence of the magistrate, I have identified accused Amit and accused Chandan. So here two persons have been identified. I have also identified the motorcycle and used by the accused persons during TI parade conducted in the field of Bhadrak High School. Then I am taking lordship to the evidence PW2. That is starts from page 548. Plus, I am reading from paragraph 1.
Yes.
I know Maguni Charan Mahanta as he was working as the manager of Central Bank of Bhadrak branch. I only know two of the accused persons present in the dock. The witness could not say the name of both the accused persons, but only pointing towards accused Chandramohan Jha and Amit Kumar. The occurrence took place 2 to 3 years back in the month of February on March at about 1:15 p.m. in front of the gate of LIC office at Bonchak. On the day of occurrence, I was working as supervisor at the tracker stand at Bonchak. On that day, my duty was from 12 to 2 p.m. At the time of occurrence, I was reading newspaper at the tracker stand. At that time, I heard the sound, firecracker, and went towards LIC office and saw one bank staff was lying on the ground and the security staff of the bank was assaulted by means of a gun. Out of fear, I returned from that place, and at that time, one barber used obscene language for which one bullet was fired towards him, which hit on his belly, and he fell down and cried for help, and he was shifted to hospital. I sat by the side of one betel shop. At that time, one girl was taking lassi in the lassi shop in front of the then Ganapati Hotel, now renamed as Mahavir Hotel. One bullet hit on the thigh of that girl, and many persons gathered there. Thereafter, both the accused persons, namely Chandramohan Jha and Amit Kumar, went away from the spot by Pulsar motorcycle towards Baleshwar. Thereafter, I returned from the spot to my house. MO 1, 2, 3 are the 3 broken pieces of the said gun. Because the gun was broken by them, which the security personnel was holding. Accused Chandramohan Jha was assaulting the security guard by the said gun. MO 4 already marked the said Pulsar motorcycle by which the accused person fled away. I had attended the TI parade inside the Bhadrak jail. During TI parade, I have identified accused Chandramohan Jha and Amit Kumar in presence of the magistrate. And at paragraph 11, at paragraph 10, I am again reading on the next page. Earlier, I have seen the accused persons at the PS after they were arrested. For the first time, I saw the accused persons, both the accused persons to whom I have identified in the court in the district jail at Baleshwar. Thereafter, I saw both the accused persons at the police station at Bhadrak. Other 10 persons were present at the police station along with both the accused persons. I have seen both the accused persons at Bhadrak jail, not at the Bhadrak police station. He has answered to the court.
Yes.
So, then I am taking lordship to the evidence of PW4 at page 555. Here, no, sorry, they are turned hostile. It is plus at 557. It is PW4. PW3 turned hostile. Here, I do not know Maguni Charan Mahanta, the manager, the informant. I know one of the accused among all the accused persons present in the dock. The witness identified the accused Sanjeev Gar by pointing towards him near the dock. I have a battle shop near the LIC officer prior to the inception of the LIC office. My battle shop is situated on the right side of the entrance to the LIC office. Of course, Sanjeev Gar has not been convicted. So I am not giving more emphasis on this particular document because state has not come up in appeal also. Once I have taken loss to one eyewitness, Manus Kumar Panna. PW7 at 568. Would you also got it? No. page 568. In the year 2007.
Yes, carry on.
In the year 2007, I have a battle shop at Bonchak in front of LIC office on 23rd February 2007 in between 1 to 2 p.m. The occurrence took place near LIC office Bonchak. At that time of occurrence, I was in my battle shop and preparing battle. At that time, I heard the sound like Dhoda. It's just cracker sound. I thought as the same as marriage season, it was the sound of the cracker. I heard halla and thereafter saw one person was assaulting another person by means of gun. After assault, the gun was thrown below the bridge in front of the LIC office. The person who was assaulting carried a tin box containing cash and fled away by a Pulsar motorcycle, which was in starting condition. The Pulsar motorcycle was earlier in starting condition by another person. The person was carrying a tin box and was sitting on the Pulsar motorcycle, started firing on all directions, and 4 persons in 2 motorcycles followed. All the 6 persons came by 3 motorcycles towards Bonchak. Is paragraph 3 very important because 6 persons have come by 3 motorcycles first. And paragraph 6 he has identified. He said that the witness identified accused Chandramohan Shah, Mohan Chaudhary, Chandan Sharma, and Amit Kumar by touching their body. All the 4 accused persons named above were assisting for committing theft. All the above named 4 persons fled away along with 2 others by motorcycle. I have already, paragraph 8 plus, I have already identified above named 4 accused persons during TI parade. I also identified the motorcycle MO4 and MO5 during TI parade. And paragraph 13, he has said, usually what happens when such type of incident happens in a particular locality, I saw there was halla and the persons were running here and there. I can't say the breadth of Pichu Road in front of the LIC office. And one Rabindra Mandal was in examiner period 13. Also, his statement is very important. That is available at page 589. Plus, I am working at Central Bank of India, Bhadrak branch. Have you also got it, plus? Page 589.
1 minute. Yes.
I am working at Central Bank of India, Bhadrak branch since January 2005. Our bank collect cash from Railway and LIC of India as per our understanding. I was used to go to collect the cash from Railway and LIC office. 1 guard and 1 peon also accompanied with me for collecting cash. We collect the cash by hired vehicle. The guard was carrying a gun and on tin box was carried by the peon while we were going to collect cash. The occurrence took place on 23rd February 2007. On the date of occurrence at about 11:45 a.m., I along with Lalmohan Singh, peon, and Dibakar Sahu, the armed guard, both are deceased lost, left the bank by a private hired vehicle to Railway. The vehicle used on the day of occurrence was hired earlier by our bank. On the day of occurrence, the guard was carrying the gun. The peon was carrying a tin box in the said vehicle. From Railway, we collected rupees 3,62,268 and kept the same in the tin box by putting a lock. Thereafter, we left for LIC office. The next page 590. At LIC office, Bonchak, we parked our vehicle near the culvert. I, along with Dibakar Sahu guard and Lalmohan Singh, peon, went inside the LIC office. From LIC office, we collected rupees 20,47,006 rupees and kept the same in the said tin box and put the lock again. Dibakar and Lalmohan carried the tin box ahead of me. While I reached near the gate of LIC office, I heard the sound of firing. On hearing the sound of firing, I became nervous and fell down. I saw 1 bullet hit on the finger of the driver. I heard the gossip of the people. Fled away. I saw 6 persons were going away by 3 motorcycles. I saw the bullet injury on Lalmohan and Dibakar. They were lying nearby. So this corroborates the earlier statement given by the other witness that 6 persons were there total loss in that operation, in that process of docaity. Then was I am taking it to lordship to the doctor who has conducted autopsy on Lalmohan Singh. Your lordship can see at page 592. I conducted plus I will also cut it. Page 592.
Right.
This paragraph 3, I found the following external injuries. That is a stitch wound with intact structure on the front of abdomen. On opening the stitches, the wound is more or less circular, punctured, lacerated wound with abraded collar around with inverted margins of diameters 1 so. And second is also, that is a circular punctured lacerated wound of 0.5 cm diameter with abraded collar along the margins with oozing of blood from it. Then third also, that is also a punctured lacerated wound of diameter 0.75 cm. And on dissection, I found paragraph 4, the head structure were in the intact, the brain intact and pale, legs were pale, heart was empty, there was blood. No, that is not so important. On its track, it has pierced ear loss. Yes, there is an established lack of, from wound number 2 and wound number 3, lacerating the structures along the track. On its track, it has pierced the loci. Loop of intestine at 3 places. There is another traced wound from wound number 1, piercing the abdominal wall. Thickness peritoneal has been confused with contusion of not legibleness and loops of intestine. But paragraph 6 is important. After examination, I am of the opinion that all the above mentioned injuries were antemotum in nature. The wound number 2 external is a bullet entry wound, and wound number 3 is corresponding bullet exit wound. The wound number 1 is another bullet entry wound. In the corresponding track is up to the site of recovery of the fired bullet. The wound number 4 is due to hard and blunt force impact. The above firearms wound are ordinarily fatal in nature to cause death. The death was due to shock and hemorrhage as a result of gunshot injuries. And in paragraph 8, the other disease has been examined. The doctor has stated that on certain subject, I conducted autopsy on the dead body of Dibakar Sahu. There at paragraph 9 plus the nature of injuries, there is an integrate on that particular deceased. All are, you will also find the circular punctured lacerated wound, irregular star-shaped punctured lacerated wound. One is circular punctured lacerated wound, and oval punctured lacerated wound. A punctured lacerated wound of size 1.5 into 0.75 on the left gluteal area, 92 cm above heel. And paragraph 10 is the opinion. No, paragraph 11 is the opinion. At page 597.
Yes.
After examination, I am of the opinion that all the above mentioned external injuries are antemotum in nature. The external wound number 1, 2, 3, and 4, and 5 are gunshot injuries. The wound number 1 and 2 were the gunshot entry and corresponding exit wound, respectively. The wound number 3 is another entry wound. Corresponding projectile was recovered from left chest cavity. The wound number 4 and 5 are gunshot entry and corresponding exit wound, respectively. All the above gunshot injuries are individually and combinedly fatal in ordinary course of nature. The wound number 6, 7, and 8 are surgical in nature. The wound number 9 and 10 are due to blunt hard force impact. The death was due to shock and hemorrhage as a result of gunshot injuries. So here 2 persons have died. So this is the examination autopsy report of the doctor who conducted autopsy. Plus on PW8 in also the evidence of PW8 is that was important. That is at page 609.
Telling me that the Caesar was before the incident.
He was the assistant administrative officer working in LI's office. Northern branch. The 609.
Yes, please.
He has corroborated the testimony, I mean the evidence of P2 13, that he has stated, I'm reading from the paragraph 1, on 23rd February 2007, I was working as assistant administrative officer in charge of office servicing department and salary saving department in LIC of India, Bhadrak branch at Bonchak, Central Bank of India. Bhadrak branch was our banker at that time. At that time, on each working day, 3 staffs of Central Bank of India, Bhadrak branch, were coming to our office. They are namely Madan Lal Babu, Lalmohan Singh and Dibakar Sahu. On 23rd February 2007, in between 12 o'clock, noon to 12:30 p.m., all the above named 3 persons have been to our branch to collect cash. So on that day, they have received the cash of an amount of rupees 20,47,006 and 90 paisa. After they collected the amount, they went outside the premises along with the box containing the cash. While I was present in upstairs, I heard the sound of cracker and saw through the window that 5 to 6 persons carried the box containing the cash after firing, and they broken the gun of the security guard and threw the same. Up to this plus this evidence of the present witness is admissible. Plus he has corroborated the testimony of PW 13. And PW 20 plus page 614. He was a manager in the Hotel Sagarin, where from the accused person were arrested. On 21st February 2007, I will also got it, 614.
Yes.
I was working at Mr. Guest House at Charampa in absence of manager, Mr. Guest House. Mr. Guest House is lodging. Register is maintained at Mr. Guest House showing the name of border. This is the state register of Mr. Guest House from 10th August 2005 to 7th April 2007, matters exhibit 15. At serial number 3780 of exhibit 15, Rakesh Kumar of Tata has made the entry showing his stay in the guest house on 21st February 2007 at about 4:30 p.m. in room 203. 2 other persons also accompanied with Rakesh Kumar. Rakesh Kumar left the lodge on 23rd February 2007 at about 11:30 a.m. Out of the 2 persons accompanied with Rakesh Kumar, 1 person remained with him and another person went away and he came during night. Exhibit 15 by 1 is the entry bearing number 3780 dated 21st February 2007 showing the date of departure on 23rd February 2007. On inquiry, Rakesh Kumar has disclosed that they have come for gutka business. They were talking in Hindi. The witness identified Chandan Kumar present in the dock by touching his body, saying that he was staying in the lodge in the name of Rakesh Kumar. So in the guise of Rakesh Kumar, Chandan Kumar staying in that particular lodge. Then paragraph 4, on 23rd February 2007, there was Dokaiti near LIC office Bhadrak. I was examined by the police after 1.5 months of the date of Dokaiti. I have identified the accused, Chandan Sharma, during TI parade. This is one of the appellant fellows. Your Lordship. And next is the evidence of PW. It is below Rabindra Kumar Sahu, PW 21, page 617.
Yes.
I know Jadimani Janaj was working as in charge of Bhadrak Rural PS. Plus, I am directly going to paragraph 4, page 618, the relevant portion. Because all these articles have been recovered. After opening the said bag, 5 guns, 7 mobile phones, 5 numbers of mobile charger, and 1 camera and cash of rupees 5,05,000 were recovered. Police seized those articles and prepared the seizure list. I, along with Madan Bhai, signed on the said seizure list. The witness identified accused Amit Kumar, Mohan Chaudhary, Chandan Sharma, Mir Ali, present in the docks, stating that those persons apprehended by the police from Sagar in Dhaba. But nothing substantial has come up by the defense for the defense in the cross-examination. And PW 24 happens to be the JMFC who had conducted TI parade. That is at page 625.
Yes.
Yes, plus. On on 5th March 2007, I was working as judicial magistrate first class at Bhadrak. On 28th February 2007, I received the case record bearing GR case number 247 by 2007, arising out of Bhadrak case number 31 by 2007 from the court of STM Bhadrak for conducting TI parade in respect of suspects. I issued notice to the witnesses and intimated superintendent of special jail Bhadrak for making necessary arrangements to conduct TI parade and fixed the date on 5th March 2007 for conducting TI parade. On this is a long statement. I am taking a lordship to the relevant portions. On 5/3, I am reading that. I am on 5/3/2007. Witness namely Manas Kumar Panda, Karthika Das, Ashutosh Sahu, Sheikh Muna, Mirza Nai, Nain, Sanat Kumar Majumdar, Anant Kumar Das appeared before me. I directed them to be present near the main gate of special jail, sub jail Bhadrak at 11:30 am. I reached at sub jail Bhadrak at 11:45 am. After perusing the UTP register at special sub jail Bhadrak, I noted the identification mark on the suspects Lammu alias Chandramohan Jha, Rushikesh Das, Lakshmandar Behra, Mir Ali or Mir Alim, and Chandan alias Sheikh Hafizuddin. And on examination, I found the marks are very negligible and could not be marked by naked eye. The necessary arrangements were made inside sub jail Bhadrak for identification of suspects Lambu alias Chandramohan Jha. The suspects were mixed with 10 number of UTPs of similar height, appearance, dress, age, and description. The arrangements were made out of the sight of the witnesses inside the jail premises. I explained Chandramohan Jha the brief fact and purpose of TI parade and instructed him to stand along with 10 UTPs in a row as per his wish. After due arrangement, witness namely Manas Kumar Panda was called to identify the suspects. Manas Kumar Panda correctly identified the suspect Lambu alias Chandramohan Jha. After identification, he was directed to remain outside the TI parade. Plus, Manas Kumar Panda has been examined as PW7. Thereafter, plus the witness, namely Karthika Das, who has been examined as PW4, he was called since to the TI parade spot, and it is paragraph 6. And I explained him the brief fact of this case and the purpose of TI parade. And thereafter, he was called to identify the suspect Lambu alias Chandramohan Jha. Witness Karthika Das unable to identify. But Ashutosh Sahu, who has been examined as PW1, thereafter witness Ashutosh Sahu was called to identify the suspects Lambu alias Chandramohan Jha. I explained the brief facts and the purpose of TI parade and directed him to identify the suspects. Ashutosh Sahu correctly identified suspect Lambu Chandramohan Jha. Thereafter, he was kept inside the jail. So it corroborates the evidence of PW1, as I have read for lordship. And at paragraph 9, plus the witness namely Sanat Kumar Majumdar, PW10 plus, was called to identify the suspects and explain him the brief facts and purpose of the TI parade and directed him to identify the suspect. Witness Sanat Kumar Majumdar correctly identified the suspect Chandramohan Jha. So Chandramohan Jha has been identified by both the persons. And then Anant Gopal Das was called to identify the suspect. You'll also get it at paragraph 10. And similarly, that witness Anant Gopal Das correctly identified suspect Lambu alias Chandramohan Jha. Now, regarding identification of Gullu, I am taking a lordship, page 634. Paragraph 35. Then the witness Karthik Das was called inside the TI parade spot. I stated them the purpose of the conduct of TI parade. The witness Karthik Das correctly identified suspect Amit alias Gullu alias Amitabh Kumar. This is one of the appellant laws. Then witness Ashutosh Sahu was called inside the TI parade spot and explained him the purpose of TI parade and directed him to identify the suspect among the UTPs. The witness Ashutosh Sahu correctly identified the suspect Amit alias Gullu alias Amitabh Kumar from among the UTPs. And similarly, Manas Kumar Panda, also at paragraph 37, your lordship gate, at page 634, witness Manas Kumar Panda correctly identified the suspect Amit alias Gullu alias Amitabh from among the under trial prisoners. So Amit has been identified. Then it is regarding Chun as Mohan Chaudhary. You'll also get page 40. Sorry, paragraph 40 on the next page, page 635.
Yes.
The witness Manas Kumar Panda, P27, was called inside the TI parade spot. I explained him the purpose of TI parade and instructed him to identify the suspect Chunu as Mohan Chaudhary from among under trial prisoners. The witness Manas Kumar Panda correctly identified the suspect Chunu alias Mohan Chaudhary. I directed the witness to remain away from the TI parade spot inside the jail premises. Then regarding the presence of Chandan Sharma, you'll also get at page 637.
Yes.
Paragraph 46. Thereafter, the witness, namely Ashutosh Sahu, was called to TI parade spot and I explained him the purpose of TI parade and directed him to identify the suspects from among the UTPs. The witness Ashutosh Sahu correctly identified the suspect Chandan Sharma among the UTPs. So I direct the witness to remain away from TI parade spot inside the jail premises. The witnesses Manas Kumar Panda was called to TI parade spot and I explained him about the purpose of TI parade and directed him to identify the suspects from among the UTPs. The witness Manas Kumar Panda correctly identified the suspect Chandan Sharma from among the under trial prisoners. So here Chandan Sharma has been identified, which has been duly corroborated by the evidence of the land and magistrate. Chunnu, Amit and Chandraman Jha plus all have been identified. And the land and magistrate, being a public official and also being a judicial magistrate, his credence cannot be questioned because that has also not been questioned by the on behalf of the defense. The legal aspect after recess clause.
All right. All right.
Above all, this is the fact. Plus the tin box carrying cash has been looted away. And 6 persons were involved and all have been identified.
Or
4 appellants.
Yes, yes. You carry on.
Supplementary item 29.
With the Lordship's permission,
yes,
I'd like to draw Lordship to some more evidence. There are some persons who are injured after getting gunshot injury. There is the examiners PW9, PW11 and PW12.
9, 11, you think you already read?
No, 11 I have not read.
Acha, 13, you read 13, yes, correct.
PW9, 11, 12, all the 3 persons received gunshot injuries.
Right.
During the course of Dakayati, you'll also get it page 579, PW9.
Right. Yes.
Plus on 23rd February 2007, I was working on contract basis as electrician in BSNL office at Bhadrak, Bonchar. On that day, in between 1 to 1:30 p.m., I had been to saloon of Bijay Barik. Bijay Barik has been given to situated at Bonchar in front of the LIC office for saving. While my saving was in process, I heard the sound like bursting of cracker. I inquired from Ajay Barik, the elder brother of Bijay Barik, about the sound, and he told me that there was firing of bullet. Ajay Barik closed half of the door, and I rise from the chair and stood on the back of Bijay Barik. At that time, one bullet hit on the belly of Bijay and also hit on my belly below navel. Due to heat by the bullet, I fell down on the ground. Ajay Barik shifted me and Bijay Barik to Bhadrak Hospital. From Bhadrak Hospital, I along with Bijay was referred to SC Medical College, Cuttack. During surgical operation, the bullet was found on my large intestine and the same was removed. I was treated at hospital as indoor patient till 20th March 2007. And he said, I have not seen the assailant. Then was PW11, You'll also get it at page 585.
Right.
Plus,
right.
The occurrence took place on 23rd February 2007 at about 1:50 at Bonchak, Bhadrak. On that day, I was going to my maternal uncle's house. It was one girl of age about 14 years.
Even he did not see the assailants.
No, not assailant, but the reason is section 397 is there. That is the reason why I'm drawing lots of attention to this part, because these persons have received gunshot injuries.
Right.
And they have been examined by the doctor who has been examined at PW 17. Just only I'm showing that three persons have received injuries. And she has stated, while I was present in the lossy shop, I heard the sound like bursting of cracker and 2 bullets hit on my left thigh and 1 bullet on my left belly. The bullet hit on my belly remained on my body and 2 bullets hit on my thigh exited. Due to hit by bullet, I became unconscious. I regained my sense at SC Medical College, Cuttack. After operation, I remained at SC Medical College, Cuttack for 29 days for my treatment. Similar was PW 12, Vijay Bari. For evidence, you'll also get as page 587.
Yeah.
Next page. As stated, while I was trying to close the door, 1 bullet hit on my chest and exited from my body and hit Kiran Kuntia, PW9 on his belly. I lost my sense. And all these 3 injured have been examined by PW 17, Dr. Gaurachandra Janna. You'll also get it at page 606.
No, I don't think they're denying all this. Nobody, they've not even cross-examined.
Obliged. Plus, chapter 17 of the Indian Penal Code deals with offences against property. And that section 378 defines theft.
Yes.
Whoever intending to take dishonestly and movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. Plus, I'm now drawing lots of attention to 390 robbery. In all robbery, there is either theft or extortion. When theft is robbery. Theft is robbery if in order to the committing of theft or in committing the theft or in carrying away or attempting to carry away property obtained by theft, the offender for that end voluntarily causes or attempts to cause to any person death or hurt or wrongful restraint or fear of instant death or of instant hurt or of instant wrongful restraint. So this is robbery. And if the number is 5, you'll also come to page, section 391. If number is 5 or more, then that is Rakayati. When 5 or more persons conjointly in laws commit or attempt to commit a robbery, or where the whole number of persons conjointly committing or attempting to commit a robbery and persons present and aiding such commission or attempt amount to 5 or more, every person so committing, attempting or aiding is said to commit Dakayati, which was punishable under section 395. And 396 says Dakayati with murder. If any one of 5 or more persons who are conjointly committing Dakayati commits murder in so committing Dakayati, every one of those persons is vicarious liability also came into operation.
No. So in your charge sheet, you've named only 7, correct? In your charge sheet, you named only 7.
No, 10.
Of the 7, 3 have got acquitted.
No, 10, my lords.
10.
120 bit is 7.
No. Charge.
Total 17 people charged.
Yes.
2 portions.
Total
One is 120 B is there. Totally disbelief, all acquittal. So for as 395, 396, it is 10 persons charged.
Out of 10 plus 4 have been with abundant caution, taking all possible care that innocent persons should not be victimized or should not be punished. That is the reason why those persons who have been identified.
What has happened to the remaining 6?
I don't know.
Of the 10, 4 have got convicted.
Yes.
What about the remaining 6?
Plus, that is the evidence they have been identified. And they have been identified in the TI parade. And also, The tin box has been recovered. And
no, I don't think following the question. 10 people were put up for trial for the offense under 395, 396, right?
Yes.
Of the 10, 4 have got convicted. What about the remaining 6?
Regarding the remaining 6, here in this case, what has happened? Because those persons who have been clearly identified, because it's not possible on the part of every person, because in such type of crime, when a crime is committed in a crowded place, because that was a very crime.
No, but you've named 10. If it was not possible to identify, you can argue all that. Here you've identified, you've named 10 people, 10 people have been sent to trial. Now you can't say we haven't identified.
I'm not saying so. Because at the investigation, 10 people have been named. But during trial, while leading the evidence, 5 persons, these 4 persons have been clearly identified by the witnesses. I have given my written note of submission, that is clear. And they have been identified. That is the reason why my humble submission for Lordship, with abundant caution, the learned trial court has convicted those.
There's no abundant caution here, sir. Either the case is proved or not proved. There's no abundant caution here. If against any of them there's no evidence, there is no evidence. If there is evidence, there is evidence. So there's no abundant caution here. 4 people have committed the crime, they got committed.
Yes,
they got convicted because of abundant caution.
No.
They got convicted because there is evidence against them.
Probably, I'm not made clear before Lordship properly, because there are 10 persons are there. Because when the evidence is being assessed by the learned trial court, again, what materials are there in so far as those persons are concerned, then 4 persons have been clearly identified. By 4, along with other materials are there. Because that the tin box which was carrying the cash, that has been stolen away, and the persons have been identified as firing towards the crowd, for which 2 persons have died and 3 persons have received injuries, and 6 persons fled away by 3 motorcycles. That part has been clear. So it is a case of Dakaiti. So if it is not coming, if other persons have not been identified by the witnesses while in course of trial, then how the trial court will convict those persons? So that is the reason why I have said that with abundant caution. Maybe
there's no abundant caution here, sir. If there is no evidence, they're acquitted.
Yes.
Where's supposed to be abundant caution? The word abundant caution doesn't arise at all. No. Benefit of doubt is one thing, abundant caution is the other.
Benefit of that.
No. Even if it is, the question is, if it's an acquittal, it's an acquittal.
Yes, sir.
There is no halfway acquittal, full acquittal, 3/4 acquittal, nothing like that. Acquittal is acquittal.
Yes, acquittal.
So out of 10, 6 have got acquitted. You have to try and follow the argument that is made, because only then you can meet the argument. If you keep arguing your case and you don't reply to their argument, then there is a problem there.
No, I have to reply them.
So their argument is this: you sent up 10 people for dacoity. 4 have got convicted. That doesn't answer the description of dacoity. As simple as that. That's how they're putting the case. What is your answer to that? See, it is as if the other 6 committed no crime. If you have sent up 10 people and 6 have got acquitted, it is as if they committed no crime.
Acquitted suppose by getting benefit of doubt, those persons.
Whatever, sir. Where is the law? Where is the law? It says if somebody is got acquitted by benefit of doubt, it is not an acquittal.
No, I'm not saying that is not an acquittal.
If it is an acquittal, it is as if that person did not participate in the crime. That is what is the meaning of acquittal.
So when there are absolutely no materials in a particular case, then the accused persons are being acquitted. But in some cases, while appreciating the evidence, the court finds that says
is that the law? Is that the law which says if A is acquitted because there is no material, that is a good acquittal. If A is acquitted because of benefit of doubt, it is no acquittal. Is that the law?
No. I'm not saying so. That is acquittal. That is acquittal. I'm not saying so. But there is one honorable acquittal plus a person.
Sir, that is for this. Don't mix up with what happens in service law.
No.
In service law,
I'm not
saying. No. This word honorable acquittal came from service law.
Yes.
Then you have to reinstate somebody in service, when you have to give him full back wages. For the period during which he was out of service because he was facing criminal trial. There you say whether the acquittal was honorable acquittal or is it on benefit of doubt acquittal. You make those distinctions. For criminal law, here we are only talking criminal law. We are not on somebody's service.
That is agreed. Because it is benefit of doubt has been extended to those persons as because sufficient materials have not come up against them and those persons have not been identified in the PI panel. That is the reason why benefit of doubt has been extended and those persons have been acquitted. And here these persons.
So what happens is 4 people actually involved plus 6 people not involved are sent up in a TI parade. So all the witnesses who identify the 4 who are involved.
Yes.
6 were, let us say, from their point of view, bystanders.
Yes.
They're simply watching what is happening. So they've all got acquitted. Today you're saying, no. They're acquitted only because they got benefit of doubt. Otherwise, they were actually involved, you're saying. On what basis can you say it?
So, plus I'm being lost to that further.
You first deal with the judgment of the Supreme Court, which was cited before us.
Yes.
Justice Lalit, I think. Where's the judgment?
That is because 2021 SC Online Supreme Court 1222 Ganeshan versus State. That paragraph 53. Now, so far as the submission on behalf of the appellants accused that even no case is made out for the offence under Section 391 IPC and they cannot be punished under Section 395 of the Indian Penal Code, as what is required to prove is involvement of 5 or more persons conjointly in committing the robbery. And in the present case, only 4 persons are tried and the prosecution has failed to prove the involvement of 5 or more persons. However, it is required to be noted that such as in the FIR, there was a reference to 5 persons involved in committing the robbery. Even the charge sheet was filed against 5 persons. However, as 2 accused absconded, the trial was split up and 3 accused came to be tried. 1 accused, Benny, came to be tried subsequently and 1 person still absconding. Even there are concurrent findings recorded by all the courts below that 5 persons were involved in committing the offence of robbery. Merely because some of accused absconded and less than 5 persons came to be tried in the trial, it cannot be said that the offence under Section 391 IPC, punishable under Section 395 IPC, is not made out. What is required to be considered is the involvement and commission of the offence of robbery by 5 persons or more, and not whether 5 or more persons were tried. Once it is found on evidence that 5 or more persons conjointly committed the offence of robbery or attempted to commit the robbery, a case would fall under Section 391 IPC and would fall within the definition of dacoity. Therefore, in the facts of circumstance of case, the accused can be convicted for the offence under Section 391 IPC, punishable under Section 395 IPC.
That is because somebody was absconding. Once you say in the FIR or you say particularly in your charge sheet, you send up people who have been found. You indicate 2 are still absconding. And if these 3 are convicted, since 2 are absconding, you can comfortably say 5 people committed the robbery. That is why I wanted to ask you, in your case, was anyone absconding? In your case, is anyone absconding? In the case we are now dealing with?
Yes. Yes.
How many are absconding?
That I have read just at the threshold. So I am just reading. I am taking again to that part of the judgment.
Actually, there's another judgment.
You'll also get this page 152.
This is a judgment you read which is supporting your case. There is a judgment, just Mr. Khurshid pointed out, which says what?
There are 2 judgments. Om Prakash is the first one, where people get acquitted.
Yes.
And therefore, less than 5 people are convicted. That's Om Prakash. That's not been overruled. It wasn't taken note of in this judgment, but it's not been overruled. This judgment on facts that there were people named, but they could not be tried for one reason or another.
Can you give us a citation, please?
The citation is AIR 1998 SC 1220. Manoj, this is in the compilation that we've given to your lordship.
No, but I thought there was a more recent judgment of the Supreme Court.
Yes. There is another one.
Another one was AI 2008 Supreme Court 3248.
Rajkumar versus State of Uttarachal. Lordships have that paragraph 19 is the relevant one.
No, there's an AIR 2021 Supreme Court.
No, that's the one that was Ganeshan.
That is Ganeshan.
I see.
Ganeshan on facts would.
We're trying to distinguish that.
Correct, because they were absconding.
Yes, that compilation, I have not got that compilation.
Yes, I've given.
No, say that.
Spiral.
No, my record. Because my learn, the following thing.
Already given.
No, so is anyone absconding in your case? In the case we are now dealing with, how many people are absconding?
Well, there is nobody absconding. They just in passing say two people are absconding. But
two others.
They haven't established that there were specifically two other persons. Those two other persons would be identified or have been identified or named, and that they were charged. All the people who had to be charged were charged. 6 were acquitted. 4 were convicted. So it isn't as though they know that there were 2 other people, except of course, my lords, in all fairness, the learned trial court has said that there were these 4 people who are convicted, and in addition there were 2 other people. But that's just a passing, which is not based on any specific evidence. My lords, the Rajkumar case, which is before your lordship, that's the 2008 SC 3248. There is a paragraph that addresses this sort of concern, and that would distinguish if your lordships have that. Paragraph 19. Because the factum of 5 or more persons is either not disputed or is clearly established.
Right.
That's what distinguishes, I believe, in with our case specifically, and that does not allow Ganeshan to influence the result in our case.
All right. I'll again ask Mr. Katkia to respond. Yes.
Yes, I'd like to go through that compilation so that I can answer a lordship's query. I have not received the compilation. That is not on me, honestly speaking. Refreshing on this person. So let me go through that compilation first, because I am arguing against my learned seniors, very eminent counsel of the country.
No, not for that, sir.
No,
you still have to. That's why it was adjourned to today. We can't go on like this.
No, sir, because I have not got the compilation. That is the reason why I'm asking for some time first.
You go through the compilation, you file a written note of submission.
Yes,
given you, I think.
request my land friend to hand over the
I'll give
company.
you another copy. I'd given.
And one aspect was a staff. Okay.
Yes. Yeah, this is also yours.
Plus, I am drawing your attention to Section 300 illustration D will find. If somebody, suppose with a loaded cannon, is full of fires at the public loss and resultantly causing death of some person, so that amounts to murder. Here, a clandestine firing has been made by this person, and because this is a dacoit with murder, and so that cannot come within the ambit of Section 304 Part 2 in any way. Yes.
No, I think they were only arguing Part 1, not Part 2.
So Part 1 or Part 2, culpable homicide not amounting murder, that will not come within that folder by humble before lordship, because that is clear from Section 300 illustration D. And it is a case where 2 persons have died and a continuous firing has been made, 3 persons have been injured.
Right. 300D. The
yes.
D illustration D.
Yes, yes.
Right. Right.
I'll give it a written note.
All right.
There's one point my learned senior would like to address.
Yes, Mr. Kush.
My learned friends will give a note on the issue of dacoity. I would want to urge your lordships to look at just a few bits of evidence as far as 302 is concerned, because as I argued, the mens rea of 302 will have to be established for each person, because there cannot be the same mens rea attributable to all 5 in case there were 5. Less than 5, it will have to be established for each person concerned. So if your lordships are even prima facie inclined to look at beyond the issue of dacoity, I would just need 10 minutes to show those specifics of the evidence in order to satisfy yourself.
Yeah. We'll finish it today, Mr. Khurshid.
If your lordships want to finish it, I will do it right away. If your lordships
yes. No, we're not adjourning it further beyond today.
I understand. And I understand. Well, there's no difficulty there. The other way we could do this, my lords, is that you've asked the other side to give a written statement.
Correct.
Submissions. What we could do is we could supplement our written submissions that are already before your lordships. I think that would take care. So we'll explain the consequence of each of these judgments, and how they relate to each other. Those additional submissions will also indicate some of the points of evidence that your lordship may need to.
Very good. Yes.
We'll do that. Because your lordship give us 1 week for this.
We'll do that.
Lordship's written submission.
We'll do that. Orders reserved. Both sides are permitted.
We want to raise another issue on the point of law, the issue of estoppel. That will take care in the note.
We'll do that in the note.
All right. To file written notes of their arguments within 1 week.
Yes.
All right.
Deeply obliged, my lord. Deeply obliged.
Not.
Obliged.
Now that Prongiri, then we go back.
Supplementary list item number 15.
May it please the lordship.
Yes.
It was passed over 22, man. 15.
Oh.
15. 15. Oh, sorry. I'm sorry.
Lordship, I am in item 15, Lordship. I am for the intervener applicants.
Yes, yes.
Lordship, this is a case where the Tahsildar Tangi and Collector Khordha, they have started the demolition drive of the ponds without giving notice to the individual pond owners, Lordship. They are doing the cultivation on their own land.
Right.
But unfortunately, without any notice, they have demolished the portions. Particularly in IA number 13647 by 21, Lordship, they have to give the response. They have not filed the reply, Lordship.
Last time you took time.
Yes, my lord. What has happened? I had tried my level best to contact Mr. Vishara to get a copy. That copy is not available, and I called him. Mr. Mahanti called him several times, and let him give a copy. I will respond next date or within 1 week. It may be taken up in a different list.
Mr.
So,
Biswal, he says he still does not have a copy from you.
Lordship, in IA number 13647 by 21, several copies has been served. If my Lord and Senior is asking to serve one copy, I am serving one copy tomorrow.
That's all. Today you serve a copy. It can be listed next week or 10 days after separately. Who will give?
Lordship, what I pray before your Lordship, the Chilka water is entirely 1100 square kilometer during the time of rainy season. And in summer season, it is 900 square kilometer, Lordship. This 200 square kilometer is the no fishing zone. So what we Lordship pray, as it is a PIL initiated by the Honorable High Court of Orissa, Lordship, what we pray, that 200 square kilometer be allocated to the persons, those who are the poorest of the poor, for having the prawn cultivation, those who do it in the natural process, without putting any pesticides, insecticides, nothing of any sort. In the natural process, Lordship, they will grow. In 93, the state of Orissa was generating highest income out of this prawn cultivation, Lordship. They are taking the revenue department, Lordship. That is why whole prayer, your Lordship, had taken into consideration the overall aspect of the peoples of across Chilka. Those are living on those who are for their livelihood depending directly on the Chilka water, Lordship.
All right. Anyway, IA 13647 of 2021, Mr. Biswal, learned counsel for the applicant, states that he will serve one more copy of this application on Mr. D.K. Manti, learned AGA, today itself. Reply be filed.
I will serve it by tomorrow.
The next date. All right, by tomorrow. All right.
May I please? I am appearing. I am appearing from VC my lordship. I am appearing on behalf of the my lordship, IA number 5545.
Wait. Let that.
Right, we'll give a date when we give a date for everything.
My lord, I would like only your lordship to come to your lordship's order dated 16th November 2021. The first para of the order passed in the writ petition, 16/11/20.
Yes.
A disturbing scenario has been presented to the court by the affidavit dated so-and-so of the collector, as well as the video clips presented to the court by the villagers of villages Pattanasi and Kadakani in Krishna Prasad area through the AC. The video clip shows that as of this morning, the prawn gheris, which had perpetually been demolished by the enforcement team on 4 occasions, the 9th October, 1st and 2nd November, 8th November, with impunity have been erected. Thereafter, your lordship directed them to remove it overnight and file an affidavit on the next day. So it was filed on the next date. The affidavit, your lordship's order is there. The next order on 17/11,
right,
at para 3. And your lordship gave specific direction that continuous patrolling will be there, and with impunity, and the provisions of the act will be applied, and see that it does not get re-emerged. Now, I have again given photos, if I may ask my learned courtmaster. Now, this is the 6th time where a huge area of land got, this is the same area of Pattanasi. This is the 6th time where huge encroachment, and these were very strong nets. These 3 photos, and this one is earthen one. Now, your lordship may see these are fresh mud. These have been deposited on the already existing earthen and the next photo I will show. Now they have constructed a house, a wooden hut inside the lake and completely taken away a portion of the lake to them. So,
what is happening, Mr. Monty? What is the point in all are sitting and passing these orders?
My affidavit.
Now they have removed that net geri, this earthen geri. I don't have information.
What is the affidavit of collector? What my learned friend is saying, that is already removed.
No, there are two things. Either patrolling is not taking place, or secondly, he's in the Tahsildar and the RI. They are in connivance with the local person for extraneous consideration. Now, with this, I had also sent them a video. The video contained the voice clip of the person. Now, the Tahsildar and the RI, he went throughout the village to identify whose voice it was, and ultimately he zeroed down on the person who had sent me the video. And he threatened them that you come to the police station, why are you sending the videos to me? And that poor chap, he was crying like anything, and he called me, sir, I have got trapped like this. So this is clear dereliction of duty. I pray some action may be taken against them. Otherwise, this is not ending, my lord. This is every day same problem.
May I add one line, Lordship?
Is there?
Ask him to come. Collector.
Lordship, before that, may I add one line, Lordship? I have also supplied the video clippings, Lordship. The hatcheries which has been demolished, that has been re-emerged, Lordship. I have also given the photographs and videos, Lordship. Today also I have supplied to my senior friend appearing for the state. And the local Tahsildar Ranger, they have been supplied with the copies. All have been re-emerged and they are continuously performing.
That area is...
That is for Krishna Prasad.
All
allegations.
My friend also pointing out a Krishna Prasad.
That Patanasi area is only barely 3 to 4 kilometers from the office of the RI.
Mr. Collector is there.
We are getting of Chilka in Krishna Prasad, Lordship.
Yes, some action may be taken against them.
Samarth Verma.
Mr. Samarth Verma.
Sir, good afternoon, sir.
Good afternoon.
Sir, we have continuously done our surveillance, sir, and there has been a joint squad, sir, by police and administration, RI, Tahsildar, everybody is there, sir, who continues on every alternate day, sir. They visit places and ensure that no re-emergence happens, sir. But we also have a helpline number, sir, where people can call and register their complaints on any emergence or re-emergence, sir. But the fact of the matter is, sir, despite a lot of efforts on our side, there has been instances of re-emergence.
No. If these photographs are being sent to the amicus curiae here,
sir,
clearly when they found that no action is being taken at your end, that's how they're sending it to the amicus curiae or to Mr. Dalai here, who's that Krishna Prasad Tahsil. He says again the hatcheries which we asked to be removed, they've all come up again.
Sir, in our control room number, sir, whatever complaints are received, sir, we take immediate and
clearly there's some mismatch, because otherwise this can't happen like this. The photograph he showed us, the mud is a fresh mud on that. So there's a whole new area that's been created for the prawn cultivation.
It takes around 15 to 20%.
And there's a hut also.
Hut has been there.
So you can't construct a hut and have all this done overnight. It must have been happening over 3-4 days.
Sir, I will personally again visit the area, sir. And
no, these two areas, both Krishna Prasad, and he says the person who sent him the video, the Tahsildar tracked him down and threatened him.
The allegation is against the revenue inspector, sir.
RI and Tahsildar both have tracked him and threatened him. And they are threatening to boycott from the village.
Sir, if you find this to be correct, you have to take action. Otherwise, the message will not go.
Absolutely, sir. If there is any credible evidence, sir, we will take prompt action.
See, the amicus curiae has been assisting us for years now. There's no need for him to, unless he's convinced, because this person who sent him the video has called him up and told him that he's been threatened.
The whistleblowers need to be protected in this
Absolutely.
sensitive thing.
If we don't protect the whistleblowers, no information will flow to the court at all, or to you.
That is correct, sir.
In my case, Lordship, the informer has been boycotted from village because the Tahsildar has been forced to boycott, Lordship, to villagers because he has given information, and Lordship, I have shown the photographs. He has been boycotted from village, Lordship. He's not getting any share and he's now staying at Puri. Lordship.
The dereliction of duty of the
Village.
Tahsildar is apparent from the face of the records. Some action may be taken against him. This will go, a message must go.
My lord, totally blaming the Tahsildar will not do the.
No, yes,
then
But here some villagers are there. I don't dispute that some miscreant villagers must be there.
Sir, there's no helpless Tahsildar in our system. If he's so helpless, he should not be the Tahsildar.
No, I don't say that. But Tahsildar cannot be blamed.
When you have a collector like this who's prepared to take action, some Tahsildar should be able to stand up to any pressure if he is under pressure.
Lordship, the real fact is that, with your Lordship's permission, may I submit? The real fact is that 99% people across Chilka, they want prawn cultivation to be legalized. Only 1% people, they are opposing to this.
No, it is a wrong statement, Lordship. It is very wrong statement. It is very wrong statement, Lordship. Just reverse, Lordship.
Clean the water. The prawn inside Chilka, natural process, if they will grow, they will clean the water. Just like the mother's milk, if the child will not suck, the pain it will cause to the mother, like that.
So all that nice dialogue is there, sir, but the fact of the matter is illegal prawn cultivation is happening rampantly.
Yes. People want prawn cultivation is to be legalized. Only 1% people, they are opposed to this.
No, so Mr. Verma, yes, Mr. Biswal, now let's Mr. Verma. So you'll again have to remove these illegal, both the farm, prawn shrimp farm and that hatchery.
Yes, sir.
So how soon can it be done, and when will you send us the videos that you've done it?
Within 7 days, sir. And also, if there is any hand in glove situation between administration and the people who are doing the cultivation, sir, very strong action we will take.
Some official inquiry this time at least should be done.
I think an inquiry should be ordered immediately.
Yes, the message must go
only for this particular Tahsil, Krishna Prasad Tahsil.
No, and that Patanasi.
That is on Krishna Prasad.
All is this Krishna Prasad.
All hue and cry for that particular Tahsil area.
Enter Chilika, 80% Chilka in Krishna Prasad, Lordship.
Today they are constructing mud houses. Tomorrow it will be concrete there. Then the lake is getting destroyed.
Remember, Saking affairs, Lordship, the government is constructing road with government sanction only to create this ponds, Lordship. I'm just giving one instance, Lordship, that is village Yandi. They have created more than 1,000 acres of pond by creating a government road in between the Chilka, Lordship. Only to create Lordship vote bank. They have created a road, concrete road. So Chilika became separated and a permanent embankment created and pond of 1,000 acres created for a particular village.
You say the amicus curiae has drawn the attention of the court to the emergence of illegal prawn gheris in the Krishna Prasad Tahsil by presenting 4 photographs.
Actually, I also given photographs.
What is the location? What do you call this?
Patanasi.
Patanasi.
That area is known as Patanasi.
In the Patanasi area. Stop. These photographs have been shared with learned additional government advocate Mr. D.K. Manti as well as Mr. Samarth Verma, Collector Puri, who has joined the proceedings online. In addition, Mr. S.K. Dalai, learned counsel, has also drawn attention to the fact that the illegal hatcheries, which were asked to be removed by this court, by the order dated.
Lordship.
Your Lordship may kindly note the counter affidavit para 7.
Yes.
That para 7.
All right.
At page 6.
Have re-emerged paragraph. A counter affidavit has been filed
by Collector Puri on dated 30th. I'm sorry. Today.
In an affidavit filed today by Collector Puri,
at para 7.
It is stated in para 7 that FIR has been lodged against Gopal Bisoi, son of Harata Bisoi of village Patanasi, for constructing unauthorized net gheris and in an area of 25 acres, and against Abhimanyu Behera, son of Jyotia Behera of village Patanasi, constructing unauthorized net gheris in Moza Patanasi for an area of 5 acres, as per the provisions of the PDPP Act. Full stop. Details have been given of registration of 2 more cases No, sorry. It is accordingly stated that 2 cases have now been registered. Paragraph. The court would like Mr. Verma, the collector Puri, to immediately institute an inquiry into how the illegal prawn gurries have come up, even while there is supervision, patrolling of the area, and the role, if any, of the local administration, including the revenue inspector and Tahsildar of Krishna Prasad. The court would like to see the videos of the removal of the illegal prawn gurry that have been shown in the photographs to the court today. Mr. Verma states that he will present those videos on the next date of hearing, which will be within 1 week from today. Then we'll have it on 17th at 2 p.m.
Lordship, along with that hatcheries, Lordship, that I have.
Can't be helped.
Lordship, this was also with Lordship, item number 21, Lordship. Item number 21 also, Lordship, this matter.
That we'll go one by one, my lord. We'll another band matters.
Along with the removal of hatcheries, Lordship. Along with
yes, and hatcheries. Both, yeah.
Along with the hatcheries.
Lordship, with respect to Kendrapada also, I request to show last 2 photographs. Now, what they are doing just for photo operation, I kindly request photo number 6 and 7. This, your Lordship, maybe the backs, one photo back. 6. They are just removing 10 feet.
That earlier photograph.
Earlier photographs.
Just hold
this 10 feet only they remove. They should cut it from the 4 sides. Now they just remove only 10 feet. So overnight the villagers come and they fill it with the mud and the pond is ready. They give these photographs that yes, we have done the demolition.
I don't understand.
No, they have removed this only 10 feet.
Removed. He says they've removed just one side.
Yes, the entire 4 corners should be removed and the water must be drained out so that they cannot undertake. Now they fill up the mud overnight and the pond is ready. And they just show that they are removing. One photograph is sent. Yes, we are doing. So, I have time and again requested the collector Kendrapada to look into this.
Is he here today? No.
Yes, yes. Mr. Rutraj.
Collector Kendrapada, please.
Yes, he is there. Let me call him. 1 minute. IA number 554545.
Don't interrupt while we are dealing with some other issue.
His mobile is switched off. Mr. Rutraj. One affidavit has been filed, my lord, on behalf of the collector Kendrapada.
Where is that?
Yes, he is there, perhaps. Florida, he is a Ganjam collector. Yes, yes.
Yes.
No, he is collector Ganjam.
Ganjam, okay.
Kendrapada collector. Achanti.
Where is the affidavit?
Yes, affidavit is there. Hard copy is there. I have filed internet. E-file it is.
How come the e-file thing?
Mohit, Kendrapada. It is already filed on 11th August. Today. Deputy Collector Kendrapada. Oh, this is the first copy. Hey.
This is a repetition of most paragraphs earlier also.
Yes.
Annexure L by 12. That is page 8 of the affidavit. We have given a.
So this demolition, this is the problem. He's saying the demolition
Yes.
that you carry out is one portion, partial demolition, not full demolition.
The demolition is one thing, and what is happening on the ground, that is another thing. They just still out 4 to 5 feet and they say entire thing is demolished.
I think in Kendrapada there is no such allegation.
No, this is how it's happening.
One instance, my lawn friend is saying, we'll take care of it. That your lordship can
Already,
take
say an
care of
affidavit
it.
has been filed by the collector Kendrapada.
No, my lord, Deputy Collector Kendrapada on behalf of
Deputy Collector Kendrapada
on behalf of collector.
Updating the current status of demolition of illegal prawn berries. Full stop. According to this affidavit, out of the 76 plots identified, covering an area of AC 319.67, demolition has been carried out in 53, with an area of AC 282.14. And the rest would be demolished after the monsoon season is over. Full stop. The learned amicus curiae, on the other hand, has presented photographs which show that in one particular prawn geri, illegal prawn geri, only one side of the wall for about 10 feet has been removed, whereas the 3 sides of the pond are still left intact. Full stop. As correctly pointed out by the AC, this kind of a demolition will not serve the purpose at all, as it takes no effort for those carrying out the illegal operation to reconstruct the 10 feet wall that has been removed, 10 feet of one side that has been removed,
My lord,
to
kindly
make the pond functional again.
kindly name that particular area so that it will.
This is Taradeipur, Rajkanika. Taradeipur, Rajkanika. In Rajkanika, your lordship.
Yeah, Taradeipur at Rajkanika.
Tahsil,
Tahsil.
Rajkanika Tahsil.
The collector Kendrapada is directed to immediately revisit the
Site.
53 number of illegal prawn geris that were demolished and ensure that the demolition is complete by draining out the water,
Draining and leveling the
ground
pond.
so that the pond does not re-emerge, the illegal pond, so that the pond for the illegal prawn geri does not re-emerge. A compliance affidavit shall be filed immediately in this court, and the photographs and proof thereof be presented on the next date of hearing.
My lord, so far as
Your lordship, my case is of Rajkanika of district of Kendrapada. There are about no counter affidavit, nothing else, illegal construction of
No
this.
need for separate counter affidavit for all of this.
No copy.
No. What is your petition about?
My illegal construction? That illegal construction of this.
We are already seized of the matter. We don't need to multiply petitions. All right. We don't need to multiply petitions.
Yes.
So whatever you have to say, whatever information you have, you give it to the amicus curiae. All right.
yes, that is better. All
Just
complainants
take down his writ petition. You say this petition complains of illegal prawn geris in Kendrapada district.
Of Rajkanika area.
And in particularly
15 villages.
Rajkanika Tehsil.
15
Full
villages.
stop. The court is already seized of these very issues in the main writ petition civil 7469 of 2017. There's no need to multiply PILS on the same issue. Whatever information counsel for the petitioner may have, it can be provided to Mr. Mohit Agarwal and amicus curiae, who's assisting the court in the main matter. The petition is accordingly disposed of. Right.
My lord, so far as Ganjam is concerned.
Item 20, my lord.
Yes.
I have filed the writ petition. Your lordships have granted interim order. Till today, the counter affidavit has not been filed. No communication was made from the DLC or the Coastal Aquaculture Authority, my lord. And we have abided by your lordship's conditions stipulated in the order.
But
We have
similar
not
matter,
taken
I
up the
think,
prawn culture.
in a similar matter, I think we have filed the counter affidavit.
No, my lord, you have not filed the counter affidavit in the 4 matters in item 20, the three matters.
I'm just giving that number.
3 matters in item 20, my lord, and 1 matter
Yes,
in item 21. In item 21, my lord, second matter.
Chittaranjan Parida.
My lord, the Coastal Aquaculture Authority approved my to grant license. The license has not yet been issued, my lord.
That similar matter, like Chittaranjan Parida, others are identical matter. In Chittaranjan Parida, we have filed counter affidavit.
You have not
Admittedly,
given me the copy.
Not given a copy?
No,
Yes,
counter-
since long I have given a copy.
No copy has been issued.
And what he means that the license has been granted, that is not a fact.
No,
because
license has not been issued.
I am just placing what is the document he is relying upon. With reference to the, I am direct to convey the approval of the competent authority to recognize your farm located at so and so district for shrimp culture internal with the recommendation of the district level committee of
me first.
Further, I am relying upon your document. Further, it is informed that the registration certificate of your farm will be issued after placing it before the authority during the ensuing authority meeting for its approval. So, registration certificate has not been issued to them.
No, while register 12, I am placing small, 3 or 4 lines.
So, unless they are issued by the competent authority,
I am directed to convey the approval of the competent authority to recognize your farm located at Nuaga, Jagannathpur, Dibakarpur village, Rajnath Taluk, Kendrapada district, Odisha for shrimp culture in tandem with the recommendation of district level committee, DLC of Kendrapada district. Further, it is informed that the registration certificate of your farm will be issued after placing it before the authority during the ensuing authority meeting. My lord, once they have approved my proposal, they have DLC proposal, then it will be placed before the authority meeting or issue of registration certificate.
Correct. But so unless the registration certificate is issued,
has already been approved.
My lord, unless he is having a registration certificate from the
Therefore, I have filed
authority,
this writ
they cannot be allowed.
I am not taking up the prawn culture as your lordship directed to me, my lord. Interim order granted that my pond shall not be demolished, my lord.
But interim order is always conditional. Your lordship has conditional order.
We not permitted him to carry out.
Yes. So let him produce the certificate. He will be allowed.
No, my prayer, my lord.
Because
your lordship direct. Let me submit. Let your lordship direct them to file the counter affidavit in my case.
I have filed counter in Chittaranjan Parida.
You have not given the copy.
I have given. I have given another copy.
Which is this 11428?
11428.
11428, my lord. All right. In 11428 of 2022, copy of the counter affidavit filed by opposite party number 4. No.
It is by Tahsildar. My lord, I am serving right now, your lordship.
Tahsildar counter affidavit will not. It will by National Aquaculture Authority, my lord. Coastal Aquaculture.
Oh, that is
they
Mr. Padhi will.
Mr. Padhi?
Our counter ta paijan to?
Yes, ma'am.
No.
Yes,
this 11428 of 2022, you had to file a counter affidavit for the Aquaculture Authority. Coastal Aquaculture Authority.
Opposite number 5. What happened to my registration certificate?
And can they? I don't have that copy. How have filed this?
Copy of what?
What they filed.
No, not IA, sir. They have filed a writ petition, 11428.
Yes, my lord will file. Lords may give 2 weeks time.
In 11428, Mr. Pari seeks and is granted 4 weeks time to file a reply of the Coastal Aquaculture Authority. The interim order to continue. Majority that to be filed before the next date.
My 20 item 27.
May I submit one thing? My learned friend is saying that we have not served copy of the counter affidavit. He has filed rejoinder. He has filed rejoinder in Chittaranjan Parida case.
No, my lord.
Yes, I have. You have served copy on me, rejoinder.
Anyway, all right. Same order in item 20. So both these will take it up at different date.
Item 27, my lord. 3 matters are there.
Now, your lordship may kindly note that copy has been served and he has filed rejoinder to that.
Anyway,
because he is saying that I have not served copy on them.
These 4 writ petitions, that is item 20 and this 11428, all of these are Manoj Kumar Mohanty matters.
Yes, my lord.
Listed on 15 September.
My lord, one thing I may submit.
Interim order may continue.
One thing I may submit. The specific.
One minute, sir. 1 minute. We are just coming. We are just coming. 1 minute.
Section 13(6) specific of the Coastal Aquaculture Act specifically states that license has to be issued, certificate has to be produced so as to enable him to allow the activities.
Anyway, we have not altered that. We are not permitting him.
Of the plot culture. Only that my ponds will not be demolished, your lordship, directly for that.
So this in the main matter, 1 minute, Mr. Biswal, in the main matter.
So far as Ganjam is concerned.
Anything else in the main matter?
Yes, your lordship. The last order at para 9, direction was issued to the State Pollution Control Board to conduct a test and report. In the meantime, on the 19th of July, the Minister of Environment and Climate Change, Odisha, has given a statement, even a statement in the House that the two parameters, that is biological oxygen demand and total coliform levels, are much higher than the specified limits in the waters of Mahanadi and Brahmani. So they themselves admit that there is very severe pollution. So
no, but you wanted in the Bhitarkanika and other places, right?
Yes.
Chilika and Bhitarkanika.
The water of Mahanadi ultimately through river Daya, it flows into the Chilika lake.
Correct.
So, and the entire untreated water from Bhubaneswar falls into that Daya river. So there has to be a check there. So I think
who was to file an affidavit for that?
Pollution Control Board.
Pollution Control Board was directed.
No. Who's appearing for
Mr.
that?
Mahanti. Santi Prakash Mahanti is the standing counsel.
Have they been served?
This notice was issued through the court.
Yeah, Mr. Mahanti is there. Mr. Shanti Prakash Mahanti.
No, he is not there.
No, he has entered there.
Yes, he is there.
Mr. Shanti Prakash Mahanti.
Yes, he is there, my lord.
My lord, we have not received any notice, my lord.
The order was communicated to you.
No, my lord, we have not received any notice, my lord.
How did you appear today?
No, my lord, I am in another case, my lord. That is in Sudhanshu Sekhar Biswal, WPC 4539 of 2018.
That is my case.
This is that case.
No, that is
I have filed a fresh cost letter and the DR has issued a notice, I think.
And there is a specific direction. A copy of this order be communicated to the Secretary OSPCB forthwith for compliance.
I mean, pardon, my lord, we have not received any notice, my lord.
Why did they not comply with when we said you have to communicate it to the Secretary?
It has been sent.
Registry for must have been sent, my lord.
We have not received any order, my lord. I am appearing in the connected matter.
So the order was communicated to the State Pollution Control Board on 28th July, he says. It was communicated to the State Pollution Control Board on 20th July.
Yes.
Are you able to hear us, Mr. Monty?
Yes, my lord. Yes, my lord. Lord, you may give me some time, my lord. I have to check up, my lord. Because I was appearing in the connected matter.
a direction had been issued on 30th June 2022 to the Orissa State Pollution Control Board to test the quality of the water both in Chilika Lake as well as Bhitarkanika.
Some time may be given, my lord. I will intimate.
Paragraph. Mr. Shanti Prakash Mohanty, learned counsel appearing for the OSPCB, stated that no copy of the order of this court had been received by the OSPCB. However, the office noting indicates that it was delivered on 20th July 2022 itself. Paragraph. Since this order is being passed in the presence of Mr. Mohanty, who is present online, it will be his responsibility to immediately communicate this order as well as the previous order dated 30th June 2022, which is available on the net, immediately to the OPSCB for compliance. The Secretary OPSCB will be present online on the next date of hearing with the test reports, which will be filed in the, which if you present online, the test reports will be filed along with an affidavit in this court before the next date.
There are 4 weeks time maybe.
No. 15 September, the other matters. 15 September. List this, for this purpose, list on 15 September.
May I pray, my lord? May I pray, my lord?
Yes.
Yes, my lord. This is case 11428. Neither copy has been served. Now we don't have any record. So respective counsel may serve the copy. Then I can set the case. All the trimmer state is there. So you don't able to know.
No, state is there. Union of India is also there.
I checked it
There
up.
are 4 cases, Mr. Mohanty. Mr. Mono.
So Mr. Mohanty may serve a copy. I can immediately.
He has left, sir. I don't know. I don't know where he is.
I will inform.
All right. Yes, Mr. Biswal. Now you can.
In item 21, Lordship, I am also standing on the same footing where my Lord and Senior Mr. Manoj Mahant was appearing, Lordship. This is my own pond, and I am doing the fresh aquaculture. My pond is away from the high tide line. They have not filed the counter. The state is to file the counter in both the cases. 13625 by 22 and 136.
Similar case like.
No, I think the state has filed its counter today.
Lordship, I have not received the copy, Lordship.
Both 13625, 13647, they filed affidavits.
Lordship, I have not received.
All right, both 13625, 13647 of 2022. Counter affidavits have been filed by the state. Copies thereof we served and consent the petitioner who is permitted to file a response thereto before the next date.
May I request my learned friend to
replies be filed by the state by the Coastal Aquaculture Authority.
Lordship, my interim order
within
may be
4 weeks. Yeah. Joined up with the next state interim orders to cut.
May I request Mr. Vishwala to take the copy from my, because we are unable to get him. Let him get a copy, take a copy from my office.
Lordship, tomorrow only I will receive this copy, Lordship.
Okay, thank you.
Anything to do with Ganjam? Nothing.
No. Ganjam is nothing. Collector has instructed me that is no illegal
All right. Just keep this on record. All right. So for one purpose, it will be on 17th for the Puri removal.
Yes.
For the remaining on 15th September. All right.
Mr. Corrida, you can go.
Right.
Thank you, sir. Supplemental list item 22. Last one.
Please, Lordships. My lords, may I draw your Lordships?
Mr. Paddy?
Yes, my lord.
We are now taking up this item 22.
Yes, my lord.
What are the instructions?
My instruction is that they have paid for 8 weeks time to file the counter.
So then some interim order has to be passed because he needs money to run his.
But it is a case of that FCR matter.
Yes, Asha Kiran Charitable Society.
Yes. But in this case, all the matters have gone to the Supreme Court. So it may not be 8 weeks. Let's make give the 6 weeks also. Who can, because
Supreme Court.
This FCRA matter,
All right.
Co-members.
My lords, can my learned friend give the reference of that Supreme Court, which of the institution have gone to the Supreme Court, and what is the issue involved in the SLP? Because here, my lords, all through, I was getting the funds, that means foreign contribution. Now, if your lordship will kindly look, section 16.
My lordship may remember the FCR matter, my lord also hear the matter. All over India, different cases are filed of the FCR matter about taking foreign contribution. Lordship also remember a person has also filed application for health region, for which my lord directed to file the affidavit.
Correct.
So Lordship may give some time. In the meanwhile, provide all the instruction to the court as well as my learned parent. There is no issue.
Mr. Party, appearing for the opposite parties, Union of India seeks and is granted 6 weeks time to file a reply. Rejoined for the next date. Both in the writ petition as well as in the IA.
And also, my lords, the reference of the Supreme Court SLP numbers and what is the issue? Copy of the.
Actually, that's a judgment of the Supreme Court, I think, on this FCR.
Yes.
You'll go on the net, you'll find out. You
But-
can find out.
Supreme Court is uphold the Foreign Contribution Regulation Amendment Act 2020.
No, I am not challenging the amendment. I am not challenging any
29
amendment.
September. 29 September.
Yes, my lord. Yes,
All right.
I am not challenging any amendment. The Supreme
Lordship may
Court.
reflect along with me, Mr. Deepak Gochai, to appear.
All right.
Let's. What can I only can appeal to your lordships that there are 240 children mentally handicapped. So at least for some the entire.
No, any specific directions you want to file an IA, sir? Then we can pass a note. All right.
Pastor matter supplementary list item 25.
Mr. Katkia, you have to submit. Yeah, 25. Section 149.
The Lordship, I am there on behalf of Mr. Pandai.
There are 4 eyewitnesses in this case. 1, 2, 3, and 4. And 4 is the injured eyewitness. Now this question is on the point of section applicability of section 149.
Correct.
The first judgment I have given, I am directly taking to lordship to 2006 volume 10 SEC page 313.
Yes.
Kallu alias Mercy and others versus State of MP.
Right.
The lordship kindly turn to page paragraph 17
Yes.
at page 320. The contention that when only 4 persons are found guilty, there cannot be conviction under section 149 of the Indian Penal Code had no merit. Section 149 provides that if an offence is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object, every person who at the time of the committing of that offence is a member of the same assembly is guilty of that offence. Section 141 requires minimum 5% for being designated as an unlawful assembly. In paragraph 18, the question has been specifically considered by this court in Mohan Singh versus State of Punjab and other 2 decisions. It is sufficient to refer to the principles as stated in Dharampal for our purpose. It is true that the acquittal of an accused person does raise in the eye of law a presumption that he is an innocent even if he was actually guilty. But it is only the acquitted accused person and not the convicted accused persons who can, as a rule, get the benefit of such a presumption. the effect of findings on questions of fact depends upon the nature of those findings. If, for example, only 5 known persons are alleged to have participated in an attack, but the courts find that 2 of them were falsely implicated, it would be quite natural and logical to infer or presume that the participants were less than 5 in number. On the other hand, if the court holds that the assailants were actually 5 in number, but there could be a doubt as to the identity of 2 of the alleged assailants, and therefore accused 2 of them, the others will not get the benefit of doubt about the identity of the 2 accused so long as there is a firm finding based on good evidence and sound reasoning that the participants were 5 or more in number. Such a case, I am just emphasizing on this, such a case is one of doubt only as to identity of some participants and not as to the total number of participants. It may be that a definite conclusion that the number of participants was at least 5 may be very difficult to reach where the participant was at least 5, where allegation of participant is confined to 5 known persons and there is doubt about the identity or even 1. But for a large number of known persons such as 18, as is the case before us, are alleged to have participated, and the court acts on the principle that it is better to err on the side of safety so that no injustice is done to a possibly wrongly implicated accused and benefit out is reaped by a large number, with the result that their acquittal out of abnormals, these I had borrowed while arguing that matter yesterday night, reduces the number of those about whose participation there can be no doubt to less than 5. It may not be really difficult at all, and it is not in the case before us to reach the conclusion that having regard to undeniable facts, the number of participants could not possibly be less than 5.
No, so this
Plus
benefit
19
of doubt, no, the benefit of doubt is as regards the number.
Yes. Here plus numbers are more than 5 in this case. Because plus in this case, so many persons have been convicted, of course, under different sections. But 149.
Participation of many is there.
No.
The participation of many is there.
Yes, no. Here participation is more. And also many persons have been convicted. It is more than 5 always.
All right.
Here it is only 5. That is the reason. I'm again reading paragraph 19. That is also very important. The accused before the trial court were 27 in number. PW4 specifically named 22 persons and further named the 4 out of them who landed the blows on him. PW3 names 12 persons who came as a group. Other eyewitnesses also clearly stated that the appellants with the other accused who were present in court had come to attack Sadruddin. As noticed, however, the trial court chose to acquit all the 27 accused. In the appeal filed by the state, leave was granted by the High Court only in regard to 5 of the accused, as they were specifically named are the persons wielding weapons and causing injury to Sadruddin and others. And as the names of others were mentioned only as being members of the assembly without any specific act being attributed to them, the High Court gave benefit of doubt to 1 of the 5 Anwar, though his presence as a member of the group was accepted. This resulted in conviction of only 4. This doesn't mean that there is no finding that there was an unlawful assembly. When the evidence clearly shows that more than 5 persons armed with swords, spears, etc. had come to the house of Sadruddin with the common object of causing injury and injured him, the mere fact that several accused were acquitted and only 4 are convicted doesn't enable the 4 who are found guilty to contend that section 149 is inapplicable. Look, a similar view also has been taken by the Honorable Appeal Court in the next judgment. That is, of course, I am not. My next judgment is Nethala Pothuraju and others for State of Andhra Pradesh, 1992, Volume 1, SCC, page 49. Then, if a charge has been framed under section 149, it is not necessary to frame further charge under section 34. It can be converted to a charge section under section 34 of the Indian Penal Code. Plus, in paragraph 2, just started this court granted leave to appeal on the limited question of applicability of section 149 of the Indian Penal Code. The learned counsel for the appellants has contended that after the acquittal of 4 accused persons by the courts below, the conviction of the appellants under section 148 and on applying section 149 of the Indian Penal Code cannot be sustained. It is argued that the appellants, being three in number, could not have formed an unlawful assembly within the definition of section 141 of the Indian Penal Code. In our view, there is force in the contents of the learning counsel for the appellants. The appellants being only three in number, there is no question of their forming an unlawful assembly within the meaning of section 141 of the Indian Penal Code. It is not the prosecution case that apart from the 7 accused persons, there were some other unidentified persons who were involved in the crime. The High Court clearly fell into error in confirming the conviction and sentence of the appellants under section 148 in applying section 149 of the Indian Penal Code on the ground that they formed an unlawful assembly along with some unidentified persons. The prosecution case from the very beginning was that A1 to A7, the named persons, formed the unlawful assembly. A4 to A7 having been acquitted, the remaining three appellants cannot be convicted under section 148 and on applying section 149 of the Indian Penal Code. We therefore set aside the conviction of the appellants under the said sections. The question still remains as to whether the appellants can be convicted under section 302 read with section 34 of the Indian Penal Code. Both sections 149 and section 34 of the Indian Penal Code deal with a combination of persons who become liable to be punished as sharers in the commission of offences. The non-applicability of section 149 is therefore no bar in convicting the appellants under section 302 read with section 34 of the Indian Penal Code if the evidence discloses commission of offence in furtherance of the common intention of them all. Here below, the number is more. So even if the 149 goes, 34 is there, but here it is not 5, it is more than 5 in this particular case. The next judgment was 2003 volume 10 SCC page 108. Also in that case, the previous judgment what I have read out before Lordship that has been followed.
Right. So all these judgments are the same.
Yes, on the same line.
Right.
And that distinction between section 34 and section 149, that they are in Chitramal. And also next another judgment, that is Birendra Singh. Also Birendra Singh was state of MP 2010 8 SCC 407. That has also been section 34 and section 149. The nature, relative scope and distinctions between them laid out in detail below.
Right.
And it has been held by the Honorable Appellate Court that section 149 is of wider scope than section 34. And in a case where section 149 applies, a constructive liability arises in respect of those persons who didn't actually commit the offence. And law is like that, right from 1925.
Barendra Ghosh.
Yes, boss.
Barendra Ghosh is applicable to 34 IPC methods.
34 and 149. 149 can be convicted to section 34.
Barendra Ghosh does not apply to section 149 at all.
No. I'm not saying so. I am saying that it's section 34. 149 is converted to section 34. That is possible.
How can it be converted? How can it be converted? Without a charge?
Without a charge, it can be convicted. That is the judgment I am showing for.
Which one? Please.
Even if charges are not framed.
Please repeat it, sir.
92 1 SCC 49, sir.
Hello, I'll check that. But your lordship,
and that's been followed in Chittarmal.
Your lordship may look at 55 Supreme Court page 274. Nanak Chand versus State of Punjab.
Yeah, I think we already cited it earlier.
That was a case where, my lords, the conviction was under 302 read with 149 for persons who were less than 5. And that argument was advanced there. Here, what has happened, your lordship may see. Your lordship may just look at the charge in the paper. Page 31. Has your lordship got that page?
Nanak Chand?
No, I'm referring to the charge in this case.
That you've already, sir. You've already referred to.
Lords, your Lordship will note there is no charge under 148 of the IPC.
Yeah, that we note.
Lords, what is 148? 148 is committing rioting, being armed with deadly weapons. Here, all of them were charged under section 147 of the Indian Penal Code. All were charged, my lords, under 341 read with 149. They were also charged with 323 read with 149, 324 read with 149, and 302 read with 149. Learned Sessions Judge, in his wisdom, after analyzing the entire evidence, his conclusion is at page
13.
My lords, page 16, my lords, miss. Page 19.
Where is the paper book?
Page 19, my lords, may see paragraph 16.
Yes, yes.
Considering the aforesaid facts and circumstances of the case, there is therefore no reason to disbelieve evidence of PWs 1 to 4 that on 1/3/2002 at about 8:15 p.m., while Rabi informant was returning from the watermelon field, all the accused except accused Buddhu wrongfully restrained him. And on his shouting for help, when Biranchi rushed there, accused Ramani stabbed by knife on his chest and Rajkishore dealt axe blow on his head, resulting in profuse bleeding. So the common object of this unlawful assembly, milords, was not Biranchi, milords. Biranchi is simply an innocent bystander who has sustained injuries, milords. Now the charge which I placed again before your lordship, milords, the charge does not say specifically, milords, as to what we did. Then the court writes, injuries on the person of PW4 are well supported by the medical report by Exhibit 6. If your lordship will look at Exhibit 6 and the deposition, your lordship will find that the injuries are not contemporaneous. Evidence of PW7, who is the doctor examining the informant, that is wrong, milords. The doctor himself admits that these injuries are caused within 6 hours from the time of examination. They are not contemporaneous. There is no challenge to the fact that Biranchi with serious injuries on head and chest was admitted in the headquarters hospital, Deoghar, where he succumbed to the injuries. Para 17, the court says, now the question is whether the death of the deceased Biranchi for the injuries sustained by him attracts a case under section 302 or it falls within the category of 304 Part 2 IPC. Counsel for the defense has drawn my attention to the decision drawn in such and such, wherein deceased was an intervener and the accused inflicted blow on the chest, which is a vital part of the body. In the facts and circumstances of the case, Honorable Delhi High Court held that no intention to kill can be attributed to the accused, and his conviction under 302 was converted to one under 304 Part 2. Then the court says, my attention is drawn to decision reported in 2002-22 OCR 320, wherein Honorable Court altered the conviction under 302 IPC to one under 304 Part 2, when single stab was inflicted in the heat of passion without any premeditation or intention. Milords, both these judgments, there is a specific charge under section 302, which is absent in this trial. Then the court writes, in the present case, accused Ekadasya was apprehended when he attempted to commit theft of watermelon in the night of 28/2/2002. For that, he rebuked PWs 1 and 3 in the following morning, which had been subsided by deceased Biranchi. Due to grudge, Ekadasya, with the other accused being armed with knife, axe and lathis, formed an unlawful assembly on 1/3/2002, night at about 8:15 p.m., obstructed the informant Rabi while he was coming to his house for taking food. On his shouting for help when Biranchi Behera came to his rescue, he was brutally assaulted by the accused, out of whom accused Ramani stabbed by knife on the chest, Rajkishore inflicted axe blow on the head, which resulted in his death in the district headquarters hospital, Devgarh, on the following morning. The sequence of events thus clearly establishes that Ramani and Rajkishore, with intent to kill the deceased Biranchi, inflicted knife and axe blows upon him. It is thus a clean case of murder by accused Ramani and Rajkishore. Now, where have Ramani and Rajkishore been charged therewith? Again, I am asking your lordship to look at page number 32. Page 32, the fifth charge. The fifth charge reads like this, that you, has your lordship got it?
Yes, yes.
That you on the aforesaid date, time and place were a member of an unlawful assembly, the common object of which was to commit the offences of wrongful restraint, voluntarily causing hurt by means of sharp-cutting weapon, which offences you knew to be likely to be committed in prosecution of this common object of the said assembly, and that some of the members of the said unlawful assembly committed the murder intentionally or knowingly causing death of Biranchi. Had the charge been there that you so-and-so and you so-and-so, that is you Rajkishore Behera and you Ramani Behera, along with others committed the murder of intentionally or knowingly causing death of Biranchi, then, my lords, Mr. Katkia's argument and the decision which he has cited would be applicable. Now, I am not in this trial answering a charge of me being accused of murder. Some of the members of the unlawful assembly are accused of causing the murder. That is the subtle difference which I am trying to highlight and which has been said so in Nanak Chand. Your lordship may see 55 Supreme Court. My lords may just look at 55 Supreme Court. If your lordship will permit me, I'll share that on screen.
Yes.
Supreme Court.
Shall I share it?
Yes, yes.
My lords. Just give me a moment.
The judgment on which my learned senior was relying on the last occasion, that is 20 persons plus were charged in that case. 20. Out of them, 3 were convicted.
That. It may be 20.
3 were convicted.
200.
And here in this case, that it is distinguishable from that one.
It is not, Mr. Katkia. Please just look at this judgment which I am sharing.
Yeah. Mahendra.
What's permission to share meeting?
Yes, yes. Yes, sir, we have the judgment. We have the text. 1955 SC 274.
Yes, yes.
We have it, Mr. Panda. Mr. Panda, we have the judgment with us. You have to unmute yourself, Mr. Panda.
I'm sorry. The principal question of law to be considered is as to whether appellant could legally be convicted for murder and sentenced under 302 IPC when he was not charged with that offense. It was urged that as the appellant had been acquitted of the charge of rioting and the offense under section 302 by 149 IPC, he could not be convicted for the substantive offense of murder under section 302 IPC without a charge having been framed against him under that section. Reliance has been placed on the provisions of the CRPC relating to framing of charges, observations of the Privy Council in Barendra Ghosh versus Emperor, that they also serve those who watch and wait, and certain decisions of the Calcutta High Court to which reference will be made later on. It was urged that for every distinct offense of which a person is accused, there shall be a separate charge. Every such charge shall be tried separately, except in cases mentioned under 234, 35, 36, 37, and 39 CRPC. Section 149 IPC creates a specific offense, and it is a separate offense from the offense of murder, punishable under section 302 IPC. Provisions of 236, 237, and 238 CRPC did not apply to the facts and circumstances of the present case. On behalf of the prosecution, however, it was urged that 149 did not create any offense at all, and therefore no separate charge was obligatory under 233 CRPC, that in any event sections 236 and 37 CRPC did apply, and appellant could have been convicted and sentenced under 302 IPC, though no charge for the substantive offense of murder had been framed against him. It is necessary, therefore, to examine the provisions of section 149 IPC and consider as to whether this section creates a specific offense. 149 IPC is found in chapter 8 of the code, dealing with offenses against public tranquility.
Then you can skip that. You can skip the reading of the section. Yes.
This section postulates that an offense is committed by a member of an unlawful assembly in prosecution of the common object of that assembly, or such as a member of the assembly knew to be likely to be committed in prosecution of that object, and declares that in such circumstances, every person who was a member of the same assembly at the time of commission of the offense was guilty of that offense. Under this section, a person who is a member of an unlawful assembly is made guilty of the offense committed by another member of the same assembly. In the circumstances mentioned in this section, although he had no intention to commit that offense, had done no overt act except his presence in the assembly and sharing common object of that assembly. Without the provisions of this section, a member of an unlawful assembly could not have been made liable for the offense committed not by him but by another member of that assembly. Therefore, when the accused are acquitted of riot and the charge for being members of an unlawful assembly fails, there can be no conviction of any one of them for an offense which he had not himself committed. Similarly, section 150 of the IPC, a specific offense is created. Under this section, a person need not be a member of an unlawful assembly, yet he would be guilty of being member of an unlawful assembly and guilty of an offense which may be committed by a member of the unlawful assembly in the circumstances mentioned in this section. 149 and 150 IPC are not the only sections in the code which create a specific offense. Section 471 of the IPC makes it an offense to fraudulently or dishonestly use as genuine any document which a person knows or has reason to believe to be a forged document and provides that such person shall be punished in the same manner as if he has forged such document. Abatement is an offense under the IPC and is a separate crime to the principal offense. Sentence to be inflicted may be the same as the principal offense. In Chapter 11 of the IPC, offenses of false evidence and against public justice are mentioned. Section 193 prescribes punishment for giving false evidence in any stage of a judicial proceeding or fabricating false evidence for the purpose of being used in any stage of a judicial proceeding. 195 creates an offense, and the person convicted of this offense is liable in certain circumstances to be punished in the same manner as a person convicted of the principal offense. 196 and 197 to 200 IPC also create offenses, and a person convicted under any one of them would be liable to be punished in the same manner as if he had given false evidence. It was, however, urged on behalf of the prosecution that 149 merely provides for constructive guilt, similar to Section 34 IPC. Then their lordships quote 34, which I am skipping. Their lordships then say, the section is merely explanatory. Several persons must be actuated by a common intention. And when in furtherance of that common intention, a criminal act is done by them, each of them is liable for that act as if the act had been done by him alone. This section doesn't create any specific offense. As was pointed out by Lord Sumner in Barendra Ghosh versus Emperor, a criminal act means that unity of criminal behavior which results in something for which an individual would be punishable if it were at all done by himself alone. That is a criminal offense. There is a clear distinction between the provisions of 34 and 149 IPC, and the two sections are not to be confused. I urge your lordship to look at this closely. The principal element in Section 34 IPC is the common intention to commit a crime. In furtherance of the common intention, several acts may be done by several persons, resulting in commission of that crime. In such a situation, 34 provides that each one of them would be liable for that crime in the same manner as if all acts resulting in that crime had been done by him alone. There is no question of common intention in 149 IPC. Your lordship may mark this. An offense may be committed by a member of an unlawful assembly, and other members will be liable for that offense, although there was no common intention between that person and other members of the unlawful assembly to commit the offense, provided the conditions laid down in this section are fulfilled. Thus, if the offense committed by that person is in prosecution of the common object of the unlawful assembly, or such as the members of the assembly knew to be likely to be committed in prosecution of the common object, every member of the assembly would be guilty of the offense, although there may have been no common intention and no participation by other members in the actual commission of that offense. Now your lordship may just note, here, my lords, who was restrained? PW4 informant was restrained. This gentleman who died, he is just a, there was no intention on this part of this mob to restrain him or to cause any attack on him. Then their lordships say again, in Barendra Ghosh versus Emperor, Lord Sumner dealt with the argument that if Section 34 of the IPC bore the meaning adopted by Calcutta High Court, then sections 114 and 149 of the code would be odious. In the opinion of Lord Sumner, however, 149 is certainly not odious, for in any case it created a specific offense. It postulated an assembly of 5 or more persons having a common object as named in section 141 IPC, then the commission of an offense by one member of it in prosecution of that object, and he referred to Queen versus Sabid Ali. He pointed out that there was a difference between object and intention. For although the object may be common, the intentions of the several members of the unlawful assembly may differ and indeed may be similar only in respect that they are all unlawful. While the element of participation in action, which is the leading feature of section 34, was replaced in section 149 by membership of the assembly at the time of committing the offense. It was argued, however, that these observations of Lord Sumner were obiter dicta. Assuming, though not conceding that may be so, observations of a judge of such eminence must carry weight, particularly if observations are in keeping with the provisions of the code. It is, however, to be remembered that the observations of Lord Sumner did directly arise on the argument made before the Privy Council. The Privy Council reviewing as a whole provisions of 34, 114 and
all right, Mr. Panda. I think yeah.
That's only paragraph 14 millions.
All right.
Paragraph 9. A charge for a substantive offense under 302, 325 of the IPC, etc., is for a distinct and separate offense from that under section 302 read with 149 or 325 read with 149, etc. This is what this bench holds. Then, my lords, they say at paragraph 11, it was urged that in view of
yes.
Lords, in para 11, the lordship say they repel the contentions of the prosecution. It was urged that in view of decision of this court in Karnal Singh versus State of Punjab, a conviction under 302 read with 149 could be converted to conviction under 302 by 34, which the trial court did. There could be no valid objection to converting a conviction under 302 by 34 into one under 302, which the High Court did. This argument is unacceptable. High Court clearly found 34 not applicable to the fact of the case, acquitted the other accused under 34. That is to say, others were wrongly convicted by the trial court in that way, but appellants should have been convicted under section 302. The High Court could not do what the trial court itself could not do, namely convict under section 302, as no separate charge had been framed under that section. Then para 14, what their lordship says is clear. By framing a charge under 302 read with 149 IPC against appellant, the court indicated that it was not charging the appellant with the offense of murder and to convict him for murder and sentence him under 302 of the IPC was to convict him of an offense with which he had not been charged. In defending himself, appellant was not called upon to meet such a charge, and in his defense, he may well have considered it unnecessary to concentrate on that part of the prosecution case. Attention has been drawn to the medical evidence with reference to injury.
It's all right, sir. I don't think we'll read the whole paragraph now. That's okay, sir.
My lords, only the last line. It was urged that if a specific charge for murder had been framed against the appellant, he would have questioned the doctor more closely about the incised injuries on the head of the deceased as well as the prosecution witness. It is difficult to hold in the circumstances of the present case that appellant was not prejudiced by the non-framing of a charge under 302 IPC. That is the crux of my submissions.
All right, sir.
I say with reference to the charge that I have been prejudiced because had there been a charge either under 302 to each of them or under 302 by 34, I would have been aware that I was charged with the murder. But here, as a member of an unlawful assembly, and the charge itself says some of the members did this. It also doesn't say that you, Ramani Behra, or you, Rajkishore, did it. And then, my lords, my submission is that when there is no charge under 148, how can a charge lie How can a conviction lie under 302? If I was not holding a weapon, a deadly weapon, how can I be held guilty of murder?
All right. Orders reserved. Right.
Your Lordship wants, I can file a small one-page.
All right. Mr. Panda states that he will file a short note of submissions. You say both parties are permitted to file their respective short notes of submissions within a week.
Nice.
All right.
Weekly list for admission item number 1.
None appears. This is a number.
Weekly list for admission item number 2.
None appears. This is a number.
Weekly list for admission item number 3.
Item number 3 may I please examine virtual also.
No,
in that case, let's say item 3, let's say.
Yes.
That the application of the presentation for a direction for the own Dharit clean bricks industry. That is my prayer, let's say, which is my prayer to.
What is saying?
Direction opposite to kind to opposite for closure of Dharit clean brick stands over the khata number 151 and plot number 1.
Yeah, I don't know what's.
It's a PIL matter. The present prisoner praying to after the closure of the the bricks company industries that has been instituted on the land which is cultivated.
So you go to the NGT, sir. You're complaining of pollution, I think. Permitting the petitioner to approach the NGT in accordance with the petition's post.
Weekly list item number 4.
No instructions dismissed.
We are for the managing director of handloom industry.
All right.
I am for the OP number 4. We are for OP number 1, managing director.
Weekly list item number 5.
None appears. This is not possible.
Weekly list item number 6.
6 months adjournment. Pray for an adjournment.
Sorry?
6 items pray for an adjournment.
No. Tell us what the matter is. This is PIL again. What is this?
That was also only the present person praying for the renewal of the license, which is annexed in order Annex 7,
There are other statutory provisions with which you can object, sir.
Object, sir, I only prefer an adjournment. I will take into instruction from the kind.
No. We're not adjourning this. Sorry.
Then it pass it over,
All right. Pass over.
Weekly list item number 7.
7, my lord. The matter become already infructuous.
Infructuous.
Yes, my lord.
All right.
Government has decided to not to.
All right.
The appearance of noted.
All right.
Weekly list item number 8.
None appears. This was not possible.
Weekly list item number 9.
None appears. This was not possible.
Appearance of noted only all the 8, 9.
Weekly list item number 10.
Yes, my lord. My lord, in this case, opposite party number 1, now opposite party number 2 has filed its counter. My lord, I shall file the rejoinder in this case.
What's the matter about, sir?
My lord, in this regard, this is my lord, page 20. I have the challenge the order of the appellate authority, my lord, instead of revising the order, the appellate authority has reduced the
How are you interested? I'm not understanding. Why is this a PIL?
My lord, this
Yes.
was, my lord,
How
this
it is
question was,
PIL, my lord?
my lord, this was the question, my lord, initially, my lord, raised. My lord, after that, I satisfied that, my lord, thereafter issued notice.
No. You still have to satisfy why this is a PIL.
My lord, here it is the land of the temple has been sold with the benchmark valuation, which was not as per the decision by the endowment commissioner, my lord. Endowment commissioner finalized the rate of 14 lakhs per acre. But the minister, that the appellate authority has reduced the rate, that is twice the base price, that is 3,86,000 rupees. So thereafter, the land has been sold, my lord. That is the question, my lord. It is the land, it is the
So counter has been filed both by opposite
Well,
parties.
I have
option
filed,
number 2.
but I have filed the counter. I have the auction purchaser.
No, my lord, I have not received the counter.
In the counter, my lord, I have
You'll have to
given-
serve a copy on him then. It's a copy of the
There
counter
is an
affidavit.
interim order operating against me, my lord.
I know. Counter affidavit of opposite party number 8 be served on counsel of the petitioner today itself. Rejoinder be filed for the next date.
Yes, ma'am.
Interim order to continue. List on
Your lordship has directed to list this matter.
15 September. 15 September.
A copy may be served to me also, my lord. I am appearing for affidavit party number 7.
7. All right.
And on OP number 2, OP
Yes.
on the state as well.
Option number 2 is.
No, a counter may be served.
Yes, we used to file.
All right.
Weekly list for hearing item number 11.
Your Lordship, and I regret to inform the court that Mr. Akash Bhuya, the conducting counsel, is suffering from high fever and cough, sir, and he's gone for a COVID checkup, Your Lordship.
All
I
right.
humbly request that the
All right.
matter
It'll
be
stay on board. It'll stay on
Your
board.
Lordship.
It'll stay on board. Right.
Weekly list item number 12. Item 12.
My lord, I am praying for an adjournment.
Why?
My lord, my learner senior is ill, so he is suffering from fever.
Follow the next item.
Weekly list item number 13. Item number 13.
The well-being and whereabout of the appellant not received by now. As noted.
When will you know, sir?
Yes, I am.
This is a report of the police or? There are two appellants, sir.
Out of 2, probably 1 has died in the meantime.
Where do you get that?
Yes,
Uday Panna. First appellant probably has died, so the death certificate is with me. Other one, Uday Oramalas Panna was died since 2016.
All right. Mr. Katke informs the court that appellant number 1, Uday Oram, died in 2016.
I had given a copy of the instruction earlier.
Where is that?
Otherwise, for lordship, scan for it.
You just say a letter has been sent to the AGA by the ISC Sector 15 Rourkela on 25th June 2022 stating that appellant number 1, Uday Oram, is dead since 2016. Died sometime in 2016. The death certificate has been enclosed. Therefore, as far as appellant number 1 is concerned, the appeal is dismissed as having abated. The cause cycle of the appeal be changed to Balko Oram, son of
Balko.
late Saharai Oram of Gundibali, Luhakera, PS Sector 15, Sundargarh. Notice is issued to the sole surviving appellant to remain present in court on the next date. Notice be served through the ISC of the concerned police station to ensure his presence in court on the next date. The copy of the order be sent. None is appearing for the appellant. Copy of this order be sent to the Secretary, Orissa High Court Legal Services Committee (OHC LSC) to assign a counsel of not less than 10 years experience to appear for the sole surviving appellant. A copy of the paper book be supplied by the registry to the Secretary, OHC LSC, who will assign it, who will in turn hand it over to the counsel assigned to the case, who will get in touch with the appellant for instructions.
Plus, free copy of the order may be granted to me.
Sorry?
A free copy of the order may be granted to me. Plus, free copy of the order. Plus.
Free copy, okay. Copy of the order be issued to counsel, please state. Just on 22nd September.
Weekly list item number 14.
14 may remain on board.
There is a report plus at flag D, Losmical Perus, flag D from IIC Rarun case.
Rarua.
Serial number 3 has expired. Rasananda Nayak. The report dated 21st October 2021 has been sent by the IIC of Raruam PS stating that appellant number 3, which number is this?
14. 1.
Ramananda Nayak.
Rasananda.
Has expired on 17 January 2017 due to illness. The appeal, as far as he is concerned, is dismissed as having abated. As regards the remaining appellants, Mr. Panda states that he is in some difficulty today.
Lords, can I find out whether the relations are willing to pursue the case so far as the conviction of the appellant number 3?
All right. Then don't say that abated. At
Let
the
it
request of
remain
Mr.
on
Panda.
board. Let it remain on board. I'll
Remain
find
on
out.
board. All right. The Passover was there, no? One Passover is meant to.
Item 6 is there. Pastoral matter item number 6.
Item 6 may please say permitted to withdraw my lordship.
All right. Counsel the petition seeks withdraw this petition.
I only prefer item 3 also, my lordship, permitted to withdraw my lordship.
Or same
Item
order.
3,
Item 3. Yeah.
my lordship. Problem, my lordship.
Weekly list item number 15.
May I please, Your Lordship? That this appellant has challenged judgment dated 25/3/2004, where he was convicted for life imprisonment, rigorous imprisonment for life, charge alleged under section 302, 201 of IPC. The fact of the matter, may I please the fact of the matter? The fact of the matter, as per FIR, the FIR is in page number 21 to 26 of the paper book. As per the FIR, the accused married PW1, Desa Samal, according to Hindu rites, around 8 years back from the incident. The incident was of 2001.
Oh, I see. All right. This will have to go before another bench. It will stay on board. It'll stay on board. We can't hear it today.
We can't hear.
We can't hear it today.
All right.
It will stay on board.
Weekly list item 16.
16, I'm the appellant only. I pray for an adjournment.
Okay.
Kindly. I was prepared
stay on
for
board.
15.
All right. All right. In that case, we'll rise now. We'll rise now.
Obliged.